May I please, my lord? My lord, I beg to mention item number 7, my lord.
Yes.
My lord, here on the last occasion, my lord, the CD was called for, my lord. However, my lord, I've been informed as per my instruction, my lord, the IO who was investigating the case, my lord, is now transferred. And the OCPS is also on training, my lord. Therefore, I humbly pray, my lord, and another date may be given, my lord, for the production of CD, my lord.
Petitioner, who is
This okay, my lord. I have already informed, my lord. My lord.
Mr. Opada, Manager, Special PP. This is what case? Special PP.
SIC vigilance.
Okay. SS?
SIC,
SIC.
bracket vigilance, VIG.
Submit that due to the transfer of the transfer of the IO case and OC attending the training, the CD could not be obtained, produced, and play for some more time. The prayer is allowed. List this matter after
3 weeks, my lord.
3 weeks. Okay.
Further, my lord, I beg to mention item number 14, my lord.
Yes.
Here, I have taken the consent of Mr. L. Perme, my lord, who is for the petitioner. My lord,
14.
item 1-4, yes, my lord.
Yes.
My lord, the LCR is here, my lord. May I humbly pray, my lord, if the registry can be directed to prepare the paper book, my lord. And in the meantime,
To
prepare the paper book. It's a criminal petition, my lord.
petition. Paper book need to be prepared
Yes, my lord.
in the criminal petition also.
Yes, my lord.
Okay.
And in the meantime, I pray for some more time till the paperwork is prepared, ma'am.
Okay. Mr. Ojingpada, Land Special PP, SC, SIC is present. Paperwork is, so LCR is called for is been received. The registry shall prepare a paperwork and list the matter after
3 weeks, my lord.
3 weeks. Okay.
Oblige, ma'am.
Will it be prepared within 3 weeks?
My lord,
Will it be prepared the paperwork?
whenever it is prepared, ma'am, after that it can be fixed, my lord. Oblige, my lord. After the preparation of the paperwork, ma'am.
This matter after the paper book is prepared and served with the parties.
Oblige, my lord. Deeply oblige.
May I please, my lord? My
Yes.
lord, I'd like to mention item number 30. 30.
30.
Yes, my lord. Supplementary hearing.
Yes.
I informed the appellants. My lord, this matter may be taken up after vacation. My lord.
Mr. Podatari, K. Tari, Land Council for the
Sole respondent.
sole respondent with the consent of the Land Council for the appellant. Praise for listing this matter after the ensuing vacation. The prayer is allowed. List this matter after vacation.
Oblige.
My lord, may I mention item number 15, my lord?
15.
Yes, my lord. This is, my lord, the quashing applications, my lord. My lord, I need to file an affidavit in opposition, my lord.
Okay.
So other party is not available today, my lord. Basically, they are Guwahati-based lawyer, my lord. So
They are
Guwahati-based lawyer, my lord.
item 15.
Item number 15, my lord.
15 is Ketama.
Kota Tamas is name is reflected, but my lord,
Have
he
you
is not
got-
appearing
Okay.
after 4 weeks. my lord.
Okay. Mr. M. Kato, Land Council for the respondent. Praise for and is granted 4 weeks.
My lord,
Okay, 4 weeks time to file counter affidavit.
my lord.
List this matter after 4 weeks. Okay,
Deeply obliged.
yes,
Should I mention item number 1 and 2?
1 and 2.
Here, the respondent number 2 was supposed to file from taken consent from the.
Okay. Mr. You are Mr.
Harpo.
Arco, Land Council for the petitioner with the consent of the respondents. Praise for listing this matter
After 2 weeks.
after 2
After
weeks.
vacation.
Okay, Miss El Hage, Land additional PP is present.
So there is interim.
There interim. Okay. The interim order passed earlier shall continue till the next date. Okay.
May I please, Lordship?
Yes.
Lordship, I beg to mention item number 26 and 27 on behalf of the other. I have taken consent from other side also.
Make appeal. Okay. Mr.
Jeeta hai.
You are for petitioner, the appellant,
Respondent.
you are for respondent,
Yes.
Islamic Council. G.
Jeeta hai.
Tari,
Yes.
Islamic Council for the respondent number. Respondent
Both the
insurance.
res- Both the respondent.
Okay. Islamic Council. You are representing all the respondent.
Yes.
Okay. Islamic Council for the respondents. With the consent of the Islamic Council for the appellant. Praise for listing this matter. When do you want you said?
After vacation, Lordship.
After the ensuing summer vacation. The prayer is allowed. List this matter after vacation. Okay.
Deeply obliged.
Mayor, my lord. My lord, I would like to mention item number 29,
Item 29.
29, Your Honor.
Yes.
Matter may be listed after 3 weeks, my lord, due to many,
After
3 weeks.
you are for?
I am for appellant.
Okay.
For state lawsuit.
Miss
Miss T said,
P
T said,
says.
SATH.
Land Council for the appellant. Praise for listing this matter after 3 weeks. Okay. Miss L. Hagelange, additional PP, is also present and has no objection. Accordingly, the prayer is allowed. List this matter after 3 weeks. Okay.
Much obliged.
Lordship, I beg to mention item number 21.
21.
Yes, Lordship.
Yes.
Lordship, matter is today fixed listed for orders. Kindly, Lordship, list the matter for admission hearing after vacation.
This is for this. What is this matter about?
Item number 21.
Quashing lordship, this is a
Quashing.
similar petition.
Mr.
D. Tali.
D. Tali, Land Council for the petitioner. Praise for listing this matter
After vacation.
after
Lordship, there is interim also. Kindly continue the interim.
vacation. Miss L. Hage, Lanet, additional PP, has no objection. Accordingly, the prayer is allowed. List this matter after vacation. Stop. Para, the interim order passed earlier, so continue till the next date. Okay.
Obliged, Lordship.
Yeah.
Yes.
Lordship, I beg to mention item number 9.
Yes.
Lordship, conducting council is out of session. The Lordship may please, matter may be adjourned after vacation.
You are Miss
N. Hondi.
Land Council for the petitioner. Submits that the main counsel for the, who is out of station, you said?
Titaba.
T. Taba, the main counsel for the petitioner is out of station, hence pray for adjournment.
Lordship, there is an interim.
The, prayer is allowed. List this matter after vacation. After 3 weeks, after 3 weeks. So when do you want, you said?
After vacation, Lordship.
After vacation?
Yes.
Okay, after 3 weeks, stop. Para, the interim order passed earlier shall continue till the next day. Okay.
Lordship, item number 18 also.
Is this also quashing petition? Okay, similar order, huh? Is there any interim order here in
Yes,
this
yes,
case? Item
yes,
18?
Lordship.
Hmm?
Yes, Lordship.
Okay, same. The interim order passed earlier shall continue till the next day. Okay,
Deeply obliged.
yes.
My lord, I beg
to mention item number 16.
16,
Yes, my lord.
yes.
Yes, my lord. Matter will be fixed for after summer vacation.
What is this case about?
This is quashing of a fire, man. Quashing of a fire.
Washing petition.
Yes, my lord.
Is there interim also?
No, my lord, no interim.
Okay.
Still,
You are
my lord.
Mr.
Yes, Aso Dalbong. A Dalbong.
Dynamic counsel for the petitioner. When do you want, you said? When do you want?
Yes, after vacation, my lord, after summer vacation. Item number 16, my lord.
Praise for listing this matter after vacation. The prayer is allowed, list this matter after vacation. Okay. Yes,
May I please, your lordship? My lord, one regular bail application, my lord, we are going to file, my lord. Can you add two, my lord? Because, my lord, brother of one, my lord, accused, my lord, is, has been died, my lord, recently, my lord, by a train accident, my lord. So regular bail application, my lord, already
I have
arrested
already
on field,
filed.
my lord. Want add two, my lord, kindly, my lord.
Okay. After the matter is over.
After, as a last item, my lord.
Okay. Last.
Your lordship, I beg to mention item number 5.
5.
Yes, I was supposed to file an affidavit, additional affidavit, and I have already filed the additional affidavit, but however, the file is misplaced, so I may be allowed to file a fresh one. And this matter may be listed after court vacation.
You are for the petitioner.
Yes, your lordship.
You are Miss
Amy Aram.
Islamic counsel for the petitioner. Praise for further time. How much time you said?
After vacation,
Okay. Further some time to file affidavit.
additional affidavit.
Additional affidavit. The prayer is allowed. List this matter after. And A is prayed for, comma. List this matter after the ensuing vacation. Okay.
Deeply obliged.
Yes.
May I please, ma'am?
Yes.
My lord, I beg to mention item number 3 and 4, ma'am.
3 and 4.
Yes, ma'am.
What is this petition about?
My lord, this is, I have challenged the order of the session just passed in
Is there
CC,
any
my lord.
interim order?
No interim, ma'am.
Okay.
Learned council, conducting
The
council,
first matter only.
yes, my
Let
lord.
it call for- Okay. The first matter, it will be called as the first matter only.
My lord,
Why you are mentioning?
conducting
Let it
council,
go.
this okay is out of station, ma'am.
Maybe, let it go. It will be first matter to be called.
Yes, yes.
Why you are mentioning?
Oh, please.
Yes, yes.
Also, I have filed a anticipatory bail, lordship, maybe listed today for last matter.
Only, huh?
Anticipatory bail, lordship, for listing, I'm mentioning for listing, lordship.
What is this matter? The offense alleged against accused?
Offense is sexual harassment, lordship. Of section 354A. Anticipatory bail.
When did you file?
Today, lordship.
Today.
Yes, lordship.
Already been list, already, you have already filed,
Yes, today file.
registered.
Maybe list as a last matter today, so it will be
Okay.
public.
Mr. No interim.
No interim.
Okay.
Interim is there. ma'am.
There is
interim of the lord, sir.
You are
Sir,
for
I am for the petitioner, my lord.
petitioner.
Yes,
I am for the respondent in both the cases.
petitioner in item number 3, ma'am.
Here, lordship, the petitioner, they are challenging the charge framed by the Larner Session Court.
Mhm. Frame in offense
In
under what section?
offense under lordship,
376.
417, 376 and 306.
abatement to commit suicide.
He is seeking for adjournment.
Yes, my lord.
Why you are seeking adjournment?
My lord,
They
conducting
speak for-
council is this okay, my lord.
Hmm?
Conducting council is this okay, my lord, in item number 3, my lord.
Okay.
He is out of his station.
Your correspondent?
Yes, in both cases.
You.
Yes, responding.
Mr.
M. Doji, my lord.
Learned counsel for the petitioner. The learned counsel submits that the conducting counsel, Mr. Who is conducting counsel?
This okay, my lord.
This okay, is out of station and has prayed for adjournment. Mr. Lauren, learned counsel for the, Temo Lauren has learned counsel for the respondent number 2 is present and has no objection. Accordingly, the prayer is allowed. This matter after
For 3 weeks, my lord.
3 weeks. Ms. Lakshmi, are you appearing here in this case?
T. Atle, Lordship. His name may be reflected, Lordship.
2 and
3 and 4, my lord.
3 and 4.
Yeah.
Okay.
Obliged.
Yes.
We have already filed our affidavit.
File
Our affidavit on behalf of respondent number 2.
already filed.
Lordship.
Okay. So who is for a petitioner? No, petitioner probably is prayed for filing rejoinder, not yet filed. None appears for the petitioner on call. As per the record dated 21/6/2024, the petitioner is yet to file rejoinder. And you are here as a PP.
No, Lordship. Government.
No, this is?
Criminal relation, the petition, but the main contention is as against our eviction notice.
Eviction notice. Okay. And now, Mr. is present, huh? Okay. In absence of the Lanark counsel for the petition of the matter stand adjourned. List this matter after 4 weeks. Is there any stay order here? No. Is there any stay order?
Lordship, proceeding is late.
Stay. Okay. List this matter after 3 weeks. Okay.
May it please your lordship.
Please, have you recorded land council? Vittori Ramha. Land government council. Advocacy.
This is a regular first appeal against an order and judgment that your lordships will find at page 182. This was basically a summary suit that was filed. It was a summary suit filed by the plaintiff, wherein the present appellants were the defendants. Now, what has happened? If I may just...
185.
Page 182 is the order against which this appeal has been preferred. 182.
Okay.
May I just read?
Yes.
But before that, I will have to give a background
Yes,
of
sir.
how this order has come to being.
Yes, sir.
Now, what has happened herein, if I will just shortly take your lordship, the recital of this case. Now, the plaintiff, whose name is Topden Puning, he has filed the case, a summary money suit before the senior division, civil judge senior division, Pasighat, alleging against the defendants, 2 persons, that pursuant to a contract for construction, a subcontract for construction of road, these 3 people, the plaintiff and the defendants, they were in the work of construction of a road. Now, therein, certain disputes arose. It was a subcontract. The principal contractor is a firm from Hyderabad called SRK Constructions and Projects Limited. Now, from them, they had taken a subcontract. The 3 partners, the plaintiff and the 2 defendants. Now, they say that they were into this project for construction. Subsequently, there has been some disputes. And because of the disputes, the plaintiff as well as the defendants, they decided that the plaintiff will come out of this subcontract because there were 3 partners. And their firm was known as Hills Trading Company. Hills Trading Company entered into a subcontract with SRK for construction of that particular stretch of road from Potin to Panging. Now, there was ultimately a decision that because of the various conflicts between the partners themselves, the plaintiff, Topden Puning, he will come out. He will come out from this arrangement. And thereafter, they entered into an MOU. These 3 partners.
He will come out means?
He will come out from this contract. The subcontract was signed by the Hills Trading Company. Power of attorney holder was Sri Topden Puning, who is the plaintiff in the money suit. Now, they were supposed to do the work. The other 2 partners, who are the defendants herein, one called Tapang Talo and one Tanga Bailing. Now, they were the 3 partners. Now, they were supposed to do the work. The defendants were the sleeping partner and Sri Topden Puning was the active partner. He was supposed to do the work. Now, internal conflict between these 3 partners started. So, therefore, they decided by an MOU that from the partnership, Hills Trading Company, Sri Topden Puning will exit from the partnership. And thereafter, these 2 partners, the leftover partners, Tanga Bailing and Tapang Talo, they will again enter into a subcontract with the original contractor, SKRE from Hyderabad, and then they will proceed with the work. Now, the dispute here is arising out of that MOU. Now, that MOU had certain conditions between Topden Puning and the other partners, that is the defendants or the present appellants. The MOU first condition was that 8 crore was the amount for which Sri Topden Puning had agreed to come out of the arrangement or the partnership. Now, this 8 crores was divided into 2 parts. 4 crores. 4 crore was supposed to be given to him outright after the signing of the MOU. Now, that 4 crores was not given to him just like that. For 4 crores, there were certain conditions thereafter. Once Sri Topden Puning would get that 4 crore, he will meet certain conditions recorded in the MOU itself. Number 1 condition is that he will leave the site because he was the active partner and he was doing the work. He will leave the site as is where is. He will take his machineries and everything. He will leave the site. Number 2 was that there were various liabilities which Topden Puning was incurring during that construction, like payment to drivers, payment for materials, shops, rations and everything. Those liabilities were there. Now, those were also supposed to be cleared by him. Now, based on these fulfillment of these conditions only, the second amount, installment of 4 crore, was supposed to be paid. So, it was not a admitted liability on the part of the other partners, but was a conditional payment. Condition was fulfillment of those conditions. Subject to fulfillment only, the other amount, the rest of the installment will be paid. Now, what has happened? I have produced all the documents herein. After this MOU was signed, 4 crores was paid to him based on the arrangement. 4 crores paid. Now, thereafter, he was supposed to leave the site. When the defendants thereafter, or the present appellants, had gone to the site, they were surprised to find, it is on record, that Sri Topden Puning had given a subcontract to a different firm, again subcontract to a subcontract, different firm called RR Constructions, belonging to his wife. Now, that firm again has given the work to be done by 2 individual contractors. And those contractors have written letters on record. I have brought all these papers on record. On record, he has written letters to the authorities the PW department and the SKRE that I am working here based on the contract, subcontract, but I'm not getting money. There are other documents also of various staffs who are saying that I have not received money. I have worked, but Mr. Puning has not paid this money. Disputes are there. All those papers I have annexed. Now, because of that, since the site was not there, the conditions that he was supposed to fulfill were not fulfilled. And this is the admitted position because the documents I have annexed, if record I'll show, would indicate that he had given all these works to his wife's firm basically. So therefore, and they were not willing to come out from that because they were already engaged. They have invested money. So they said, we don't know you. I am there as per our contract. We are working. I have not received money. We will not leave. So the dispute continued. Ultimately, the principal contractor, SKRE Construction, who is the ultimate responsibility for the road, they looking into all these issues, terminated our subcontract. So what was our purpose? Our purpose was Mr. Puning will come out. We will pay him the required dues, first installment. He will meet all these liabilities, clear the site. We will enter into a subcontract with the original SKRE Constructions, and then we'll proceed with the work. It is a commercial transaction. We are paying because we are anticipating that we will ultimately earn money out of this by entering into another contract. So because of all these issues, my contract itself, subcontract itself with Hills Trading was terminated. It is annexed here. I'll show that annexure also. Now, therefore, that subcondition or that condition having not been fulfilled, the MOU, which was conditional, becomes void as per Contracts Act, Section 56, because obligatory conditions or obligatory works were supposed to be done. I do this and you do that. Now, since he has not done his part, his obligations were not there. I am also not obliged to pay the second installment of 4 crores. The very MOU itself would indicate, that it was a conditional payment. It was not an admitted payment. Now, the situation was like this. Then, this money suit was filed. Summary money suit. Now, Order 37 summary money suit is for...
After termination.
Lordship?
Money suit was filed after termination.
Yes, Lordship. Yes, Lordship. After termination. Money suit was filed by Sri Topden Puning against us based on that MOU, saying the MOU had a clause that you are supposed to pay me the second installment of 4 crores. That having not been paid, I have filed this case against the present appellants, the defendants therein. Now, Order 37 CPC says that summary suit can be filed only when it is a case where the amount is admitted, where it is a liquidated claim, where it is a debt written in a contract. 37 I'll produce, so I'll show. 37 summary suit is like when there is nothing to defend. If there is nothing to defend, then for expediting the trial process, a summary suit is filed. Now he files a summary suit. Now in a summary suit, liberty or that opportunity is given to the respondent to file an application asking for whether you have anything to submit. Do you want a leave to defend? Do you want to defend your case? Similarly, herein, we filed an application pursuant to receipt of notice. We filed an application before the Pasighat Court saying that this is not that simple. It is not an admitted liability. So a trial has to take place and we filed an application. In the application, we annexed those documents that it was even given subcontract to RR Constructions, his wife firm. So therefore, the site was not ready, that they were demanding money.
The petition, the plaintiff has given subcontract to the wife's firm after the execution of the MOU.
No, it was done 2 months prior to that. And it was discreetly done because we were the sleeping partners.
So at the time of MOU, this matter was not brought.
Not brought. It was not there and not disclosed. So when we ultimately reached the site, these 2 persons are otherwise senior persons, the present appellants. One is around 74, other is around 60, something like that. So they were just investing money into that project. So when they actually went to the site, then they came to know about the situation. And those papers we have brought in our application to defend. We had shown those papers on record saying these are the disputes therein. So the MOU condition that he is supposed to fulfill, he having not fulfilled that, I am not supposed to fulfill my part. And it requires a trial. It requires hearing. It requires evidences. Witnesses have to be heard. It's not that simple. Had it been a loan agreement, signed by both the parties. I accept the signature. Amount is supposed to be paid. Maybe a summary suit can lie. But against an issue that is already conditional, the MOU itself is conditional. So we showed for a right to defend. Now the learned lower court heard the matter and passed an order on 29/4/2024. Now in that order, the Honorable Court has held, we will give you a right to defend, but you are supposed to deposit 50 lakhs before this Honorable Court. So it was a conditional grant of leave to defend. Now, I'll produce a Supreme Court judgment also, which says right to defend is the general rule. To reject the right to defend is an exception. And the Honorable Supreme Court has given various stages or various situations into which right to defend has to be given unconditionally. When number one, I'll just produce, number one would be when I have been able to produce documents that indicates that there are prima facie evidences that a trial is required, then right to defend has to be given without condition. Second is, even if there are trialable issues, even the issue seems to be trialable, tomorrow he will be successful, not successful, the court may not come to a finding on that day. But if it seems that the issues are trialable in nature, right to defend has to be given, but without condition. Third and fourth is, if it is vexatious, if it is frivolous, then right to defend may not be given or may be given by condition of deposit security. So those kind of different stages have been incorporated in the judgment of the Supreme Court. There are various judgments. I'll produce the latest judgment. So on that basis, our case was that since we have been able to produce prima facie evidence, so therefore that we should have been given unconditional leave to defend. Now the learned lower court had given us 3 weeks time to make that payments. Now we were exploring the possibility of filing a civil revision before the Honorable High Court because of that condition of 50 lakhs. The parties are also not financially that well off. So 50 lakhs just like that. So we wanted to explore the possibility of filing a civil revision. When the date came, the 3 weeks was over on 25/2024. 3 weeks time was given. On 25/2024, we filed an adjournment application before the learned lower court. We stated 3 grounds therein. We stated 3 grounds. Number one, we said that we were very candid in disclosing everything in our adjournment. Number one, we said we are exploring the possibility of approaching the higher courts, challenging this order. Number two, we could not do that within this 3 weeks time because of the ill health of the present appellants. And number three, we also said that parallelly, we are also trying to collect or arrange for the money because in the event the Honorable High Court doesn't give us an order in our favor, then I need to oblige to your Honor's order. So therefore, we are also alternatively trying to arrange the money. Financially, we are not that well off. So 3 things we wrote in our application. The learned lower court, by this order, the impugn order 25/2024, recorded all our grounds. Then said the other side has objected. Thereafter, without any reasoning, directly proceeded to pass final orders based on the plain paper, the plain document, because there was no defense from our side. It was almost like ex parte, no defense, and passed an order directing payment of 4 crores along with 5% interest per annum. So this is where we stand today. So in my humble submission,
Time limit given when
time limit for lordship.
time limit for payment within how much time? No.
No. Accordingly, both the defendants are jointly and severally directed to pay the total sum of rupees 4 crores to the plaintiff as per the MOU, along with interest of 5% per annum from the date of passing of this judgment and order. So immediately that 5% starts. So this is where we are standing. So therefore, in my humble submission, this order probably is not an order that has been passed in due course of justice. This is a perverse judgment. At least that opportunity of approaching the higher courts to file a revision challenging that 50 lakhs condition should have been allowed to us. The learned lower court proceeded in haste and passed this order. So this is the case in a nutshell. Now, for your lordships, proper appreciation, if I may show that memorandum, MOU.
MOU with the condition.
Yes, MOU Lordship will find at page 52. Lordship got that?
Yes.
May I just read this? This memorandum of understanding is executed on the second day of 2021 at Hyderabad, Telangana. Now, Lordship has seen the partners. One is Sri Tanga Bayaling and number 2 is Sri Tapang Talo. They are the present appellants hearing. And they are all partners of, Lordship will see, Hills Trading Company. Number 3 is Sri Tobden Puning, who is also a partner of MS Hills Trading Company. Now, MS Hills Trading Company is registered as a partnership firm having its office such. All partners are the managing partners of Hills Trading Company. C, clause C, if your Lordship will kindly just see. The company is executing a part of the construction work of the project, construction of 2-lane from Potin to Panging of NH 13 from kilometer 314 to kilometer 351, package 9 of the state of Arunachal Pradesh under Arunachal Pradesh package of roads and highways SRDP with the EPC contractor SRK Constructions and Projects Private Limited. Then D. There has been arising some misunderstanding between the parties during the project execution, which resulting the delay in completion of the project as well as the gap between the parties seems more conflict. A joint meeting between the parties and the EPC contractor was convened on this day along with the witness for amicable reconciliation and of misunderstanding, and the following points have been agreed between the parties unanimously. Now, this is very important that number 1, the first and the second party shall pay the third party a lump sum amount of 8 crores towards the compensation, expenses, profit and loss, contribution, taxes, shares, royalties, miscellaneous payment, all the matters related to projects, company, etc., all complete as per the payout structure in 2 installments as below. Number A, the first installment of 4 crores will be paid on 4th August 2021. This has been already paid. Now, B, all the existing liabilities like machineries, rentals, labor payments, staff salary, material suppliers payments, market loans, any miscellaneous payment, and all matters pertaining to the project stress from kilometer such and such shall be held responsible by the third party, that is Sri Tobden Puning, and settle all those liabilities after receipt of the first installment. Number 2, the second installment of 4 crores shall be paid on 31 August 2021 or from the funds received against the stage certificate, whichever is earlier, subject to, this is very important, Lordship will see. Page 54, that first line, whichever is earlier, subject to fulfillment. So this was a conditional agreement. Subject to fulfillment. Number 1, handing over of the project site, clearance of all the liabilities as per point B above. Number 3, demobilizing of men and machinery by the third party. So the condition was 4 crores upright payment already received. Thereafter, he is to meet these 3 conditions. And only thereafter, subject to fulfillment, that payment would have been made. The third party shall leave the project site and company in as is where is basis on the reference MOU. Number 2, it is agreed unanimously to execute the partnership dissolution agreement by duly exiting the third party from the partnership entered by the parties and a fresh partnership deed. So this was what was they were anticipating what they are going to do, and a fresh partnership deed will execute with another party named Yumpe Taipodia immediately on the time of and payment of second installment mentioned such and such. No share liability, partnership, connection in circumstances of the HTC projects. This is not very important. The compromise agreement is executed such and such. Number 5 is a bit important. Clause number 5. may I just read? The EPC contractor, that is the principal contractor, will cancel the subcontract dated 8 August 2020 and any other MOU entered with Hills Trading Company with immediate effect and hand over the original contract agreements to the EPC contractor and a fresh agreement to the HTC Hills Trading Company as per terms and conditions of the project agreement. So what was contemplated was,
So this EPC with the.
EPC is that SRK Construction, the original.
Contract will cancel.
Yes. No, that earlier subcontract, the subcontract, they will cancel the subcontract. They will close the subcontract and enter a fresh subcontract.
Yes. This is in the condition of the.
Yes. No, condition was what the purport of this MOU. Lordship will appreciate the purport of the MOU. MOU was that the active partner will exit, 4 crores will be paid to him. Then he will meet all the liabilities, clear the site. As Lordship has seen that clause C, clear the site. And thereafter, his agreement will be cancelled. They will enter into a fresh agreement with the original contractor, and then they will proceed with the work. Because they are here to do business. These are contractors to do business. If they are paying some money to that person, they want to continue with the subcontract work. So this was what was the MOU.
So it was, the project was handed over.
It was not handed. If there is nothing to clarify in the MOU, then I can proceed further, Lordship.
Okay. Okay, thereafter?
Lordship is on page?
Yes. Thereafter?
Yes, Lordship. Now, Lordship will come to the next page, page 55. This is dated 23/6/2021. Top portion, Lordship will see, right-hand side, the left-hand side, top portion. Page 55, Annexure 7.
This was first.
On 23/8/2021.
Yes.
Hereby, the authorized representative has been changed. I have not shown the earlier document wherein Topden Puning was made the authorized. If Lordship will kindly come to page 51, just for a moment. I missed out on that page. Page 51. Earlier,
Okay.
page 51, Lordship has that.
Yeah.
This is the letter written by the managing director of that SKR company. Page 51. Letter written by the managing director of the principal contractor of Hyderabad. He has made Mr. Topden Puning as the authorized employee, as well as he's holding the position of vice president for doing the following work under the project. So this was the status given to him at that point of time. Now, subsequent to that MOU, wherein it has been decided that he will exit, the representation has changed. This is what I wanted to just place.
So this is after the first execution of the first
Yes.
MOU between the respondent
Respondents. Yes, Lordship.
and the principal contractor.
Yes, Lordship.
Okay.
So now, after that, now I'll take your Lordship to page 58 is the original and 59 is the typed copy. Now, this is dated. Lordship will come to page 59, the typed copy. This is dated 26/8/2021.
Yes.
Subject is handing over of the project working site regarding. Now, this has been signed at page 58. Lordship will see has been signed by Sri Tanga Bailing and Tapang Talo, the present appellants, the partners.
Yeah.
Now, what they say on 26/8/2021, as you are quite aware of the fact that an agreement MOU was entered in between Sri Topden Puning and Sri Tanga Bailing and Sri Tapang Talo for handing over of the project site from such and such package 9 on 2nd August 2021. But we regret to inform you that only few days is left for expiry of our agreement with Sri Topden Puning has not handed over the project site nor he had cleared the liabilities as per our agreement. In this connection, we would like to remind you that an amount of 4 crore has been given to Topden Puning as an advance for clearance of all liabilities related to this project. But we are pained to understand that still he has not taken any initiative to clear the liabilities as per our agreement. Also, we would like to mention here that as per our agreement, our team had visited the project site to assess the ground realities, but few contractors have revolted against our team for non-clearance of pending liabilities. That I lordship had told, just indicated that regarding that his wife's firm been engaged. So these contractors they are referring to. Under such circumstances, we would like to request your honor once again to direct Sri Topden Puning to clear all pending liabilities, handing over of the project site as per the agreement, and timely execution of work. This referred to our verbal discussion held sometimes in the second week of August 2021. Now, page 60.
26.
That's it.
And this,
Page 60.
just a minute, page 51 was written on,
Page 51 was written. That's it. That page is a bit. That date, there is a black mark that is a difficulty. But if your lordship will see, page 50. 50 also indicates the same thing. Page 50.
50.
50, lordship. This is dated 19/11/2020. 50. Right hand side top corner.
1911.
19/11/2020.
Okay,
This is also given by SKRE for Topden Puning as the authorized representative.
okay, no, just because thereafter this 55.
Yes, lordship. 55.
Where is the date?
55 left hand side top corner. Left hand side top corner. 23/8/2021 lordship. Just seen that here lordship.
Yes,
Yes.
so. Just a minute.
MOU was
So,
2nd August.
After this 23/8/2021, only this 25. Because on 23 already he was authorized.
No, what I'm saying is
Hmm.
the principal contractor at that earlier point of time had authorized him to do all the work because he was the power of attorney holder also.
This was the principal contractor on 23/8/2021 already authorized.
Yes. One
Another-
Sri,
Another person.
yes, G. Satyanarayan Reddy, because he has exited.
So then when this was authorized, authorization is only after the possession of the site.
No, this is not regarding the HTC,
Okay.
Hills Trading Company.
Hmm.
It is the principal contractor.
Hmm.
The principal contractor had therefore, because they had given a subcontract to Hills Trading Company, so they made Topden Puning their representative because they have to earlier because they have to write letters, take bills from the government authorities.
No, thereafter, after the execution of the MOU between these three parties.
Yes, Lordship.
The plaintiff and the respondent, then probably the two respondent, the defendant and the principal contractor must have entered fresh MOU.
It's not been done. That's what I'll show.
No, then how this authorization? 23?
This is an independent authorization. It's an independent authorization by the principal contractor because they will have to have a representative there.
Yeah.
Merely giving a subcontract, they cannot just sit there blindly because ultimately, if something happens, they will be blacklisted. Money will come to their account. Then by escrow account, it comes. So this is just their representative.
This authorization is not connected with these two defendant.
No,
And
no.
okay.
I am just producing this letter to show that Topden Puning's role, which he had earlier, has been taken off the radar. He is no longer there
Okay.
because after that MOU, the principal contractor has also changed their authorized representative. Only to that extent, I am showing this document.
Okay.
Thereafter, Lordship has seen at page 58, 59, we have been writing to the principal contractor that even after the MOU has been signed, Sri Topden Puning has not left the site, have not cleared the site has not been handed over. Now, if a lordship will come to page 60, another letter on 10/9/2021. Type copy is on the next page, lordship. 10/9/2021. Again, we write This is in continuation of our letter dated 26/8/2021 regarding handing over of the project site in Arunachal. In this regard, we would like to inform you that in spite of continuous effort, Sri Topden Puning has not handed over the project site and violated the MOU entered between us on 2nd of 2021. Under such circumstances and finding no alternate ways, we would like to request Your Honor once again to take suitable action against Sri Topden Puning for the larger interest of people of the Siang and West Siang district and other stakeholders. Now, these letters have been received by the principal contractor. The original pages, Lordship will see the acknowledgement. Now, the reason for not leaving the site, that Lordship will find from page 61. I have given the type copy at page 67, Lordship.
Yes.
Page 67. This is to RR Transport. And Lordship will see the work. This is for the same package 9. RR Transport. Widening of existing road of 2-lane standards along with improvements such as from Potin to Panging, package 9. Lordship may just indicate that package 9 is the package. Chain is from kilometer 314 to 351. Work order for construction of artwork from Senes such and such. This is reference to your price quotation and subsequent discussion negotiations held in the subject. You have explained that you have visited the site, assessed the work site condition, and then quoted to us. So through this, a work order was given. Subject Lordship will find work order for construction of artwork from Senes such and such and such. Now, this work order has been signed. The original, if your Lordship will come, page 66, your Lordship will say the original, the signature is there. Though the pages are a bit non-legible, page 66.
Yes.
Below. Yours faithfully for SRK consultant. This signature is of Topden Puning. Authorized signatory, because he was authorized signatory at that point of time, only in the month of August. So this was given by Topden Puning. And at page 75 was their acceptance. 75 and 76 was the acceptance of this subcontractor, RR Transport.
Acceptance by?
Acceptance by RR Transport, the subcontractor. That is Topden Puning's wife's firm.
75.
Page 75 and 76 is the type copy, Lordship. I, MSRR Transport, acknowledges the receipt of the original work order dated 22 June 2000. This should be 21. And confirm that all terms and conditions mentioned are acceptable to me, and thank you for placing the trust. Now, so these were things that were happening discreetly behind our back, which does not find the mention Lordship had seen in the MOU. It doesn't find any mention. It says the site will be cleared. Now, if your Lordship will see,
MOU was executed on August.
2nd August, Lordship.
So this was in the.
This was on 22nd June.
2021.
Same year.
No, this is 2011.
No, 11, they have typed it wrongly, Lordship will see. If a Lordship will see page 75, while typing, they have typographically made that mistake. 11, the contact was even not there. It's 21, Lordship. Now, if your Lordship will come to page 79.
Yes.
Page 79 is a complaint that has been given by the two contractors who are working in that particular site to the Deputy Commissioner. Herein, they have stated that they have been working, but till date, their payments have not been made.
So this was
This was dated 30/9/2021, page 77 top, Lordship.
So this is subsequent to the execution of the MOU.
Yes, Lordship, yes.
And then after payment of the 4 crore,
Yes, Lordship.
so this then is supposed to be with the defendant. The work, the site is supposed to be with the defendant.
Yes, this payment was supposed to be paid by Top Den Puning. Because the condition in the MOU was, after payment of the 4 crore, he was supposed to clear the liabilities. Now, this contractor, they write that we have been working there under RR Transport, the subcontractor, but payment has not been made till now. That subject, if your Lordship will see, of the letter, complaint against Sri G. Satyanarayan Reddy, a general manager and authorized person on this, for not fulfilling the guidelines of contract between RR Transport, West Siang, and SKR company.
So these, okay.
The difficulty is they are not following the contract in its actual form. They are saying SRK company because it has been signed by Top Den Puning as an authorized representative. But the signature Lordship has seen that it was signed by Top Den Puning as a representative of SRK. And these people are saying,
Where?
yes, Lordship, that page again, if your Lordship will come to that agreement, that contract, subcontract, page 66. Page 61 is the subcontract given to RR Transport, and page 66 is the signature.
Signature of?
Top Den Puning.
Okay.
This T, if your Lordship will able to just make out, this is Top Den Puning.
Hmm.
Because he was the authorized signatory in the month of June. Only in August, principal contractor has changed him. So now Lordship has seen that after the contract, payments have not been made. We have gone to the site. We have seen that there is a different contractor working there. Those contractors' personnels also on 30/9/2021, page 77, makes complaints to the Deputy Commissioner that our subcontract, RR Transport contract, payments have not been made. Page 77. Page 81 also there are complaints. Page 81.
Different contractor.
Different contractors. This is for art cutting bills for 7 months. So you will see the subject. Subject itself makes it clear. Prayer for immediate payment of art cutting bills of subcontractor, 7 months salaries of SRK company employee and vehicles. And the contractor signatures are there.
So this was to be, this is the liabilities.
Liability. These were
Which was to be paid by?
Top Den Puning as per the MOU. This I am just producing for Lordships to indicate that what was the condition in the MOU is in dispute. I am not saying that Lordship will pass a judgment today against Top Den Puning. But what I am saying is, it was not a summary suit. It could not have been a summary suit.
Okay.
Trialable issues were there. If trialable issues were there, then I have to be given the right to defend unconditionally, as the Supreme Court has said. I have been able to produce documents before the trial court, learned lower court, to indicate that there are disputes. So allow us to file our written statement, allow us to bring them as witnesses. The entire trial has to take place. And if he ultimately succeeds, he will get the money.
Notice can go.
Notice, and I need a stay on this order because
stay, need to deposit of some amount.
The issue is there is a Supreme Court judgment I can produce. It says in special circumstances, when it is totally a miscarriage of justice, even a security or even no security can work. If I may just, because to deposit the money, again, I've come back to the same position, square one. I wanted to come, because basically I am challenging that interim order, that interlocutory order of conditional. So though the judgment has been passed immediately, but I am challenging both the orders. My basic grievance is that order where conditional 50 lakhs was given for payment, which I wanted to challenge before the High Court, but time was not given to me and immediately order was passed. So both the orders are under challenge hearing. So my basic case would be, if that order has to go, the appellate, the judgment also has to go. Because my ultimate prayer is that the judgment is based on the interlocutory order. So the judgment does not contain anything new. It simply says an order was passed, condition was given, they have not complied, plaintiff has objected, so I'm passing the judgment. So therefore, in my humble submission, it is not a pure case where I have challenged the final order. It is a case where I have challenged both the orders, because it is interlinked. And against interlocutory order stay, the requirement under that rule probably will.
Where is that order where you are directed to pay 50 lakh?
Yes, Lordship. Lordship will come to page.
Has that order impugned?
It's been impugned, Lordship.
Okay.
Page 169. Page 169 is the order.
Okay.
And it ends at page 177. Lordship will see the last paragraph.
Yes.
In the light of the discussions aforesaid, this court is inclined to grant an opportunity to the defendant to prove their case, as they had claimed they have no knowledge of the subcontract to MSRR Transport. It was placed before this honorable court, that trial court, who continued to work at the project site after the execution of the MOU, thereby disentitling him the remaining amount of 4 crores as provided in the MOU. But the leave to defend is granted with a condition of deposit of 50 lakhs. So my entire case is, if the trial court has come to a prima facie finding that there was a subcontractor in the form of RR Transport who was working there, and therefore the site could not be cleared, and therefore I am given the liberty to file my defense, then it is a case where I have been able to make a prima facie case. Then in that circumstance, the Supreme Court, if I may just put you the judgment now, the Supreme Court has said it has to be an unconditional leave for defense. If a lordship will come to internal page 12, paragraph 32.1. Uh, 32.2, lordship, 32.2. Internal page 12. I'm just reading those relevant paragraphs. In ID, paragraph 32.2, I'm just reading that relevant paragraph, lordship.
Yes.
In IDBI trusteeship, this court modulated the aforementioned principle and laid down as follows. Accordingly, the principles as stated in paragraph 8 of Mitchell case will now stand superseded, given the amendment of Order 37 Rule 3 and the binding decision of 4 judges is as follows. Now, first you will see the conditions. Number 1, 17.1. If the defendant satisfies the court that he has a substantial defense, that is a defense that is likely to succeed, the plaintiff is not entitled to leave to sign judgment, and the defendant is entitled to unconditional leave to defend the suit. Number 1 condition. The plaintiff is not entitled to an immediate judgment, a signed judgment. Rather, the defendant is entitled to unconditional leave. Let's just see that. To defend the suit. So the number 1 clause is that if the defendant satisfies the court that he has substantial defense, which I have been able to do in this case, I have a substantial defense, then I am entitled to unconditional leave. The last line, unconditional leave to defend the suit. Number 2, that is a step down. If the defendant raises trialable issues, indicating that he has a fair or reasonable defense, although not a positively good defense, the plaintiff is not entitled to sign judgment, and the defendant is ordinarily entitled to unconditional leave to defend. So in the two different stages, first is prima facie case, substantial evidences. The learned court has in his judgment recorded also that this ground is there. Then I am entitled to unconditional leave to defend. Even if in a second scenario, I have trialable issues, maybe I might not win the case later on. Still, I am entitled to unconditional right of defend. Then number 3 is, even if the defendant raises trialable issues, if a doubt is left in the trial judge about the defendant's good faith, this is a case where the faith is under consideration, good faith, or the genuineness of the trialable issues, the trial court may impose conditions both as regard time or mode of trial, as well as payment into the court for furnishing security. Care must be seen that the objects or provisions to assist expeditiously disposal of commercial issues is not defeated. Number 4 is, if the defendant raises a defense which is plausible but implorable, the trial judge may impose conditions as regard the time and the mode of trial as well as payment. So in these situations where the very bona fide of the applicant is under doubt.
We issue notice, and since there is no time limit, so
But that 5% is going on, Lordship. Lordship will see that order. What is the judgment? At pace, it may be stayed till the notice, till the respondent appears. Till then it may be stayed. Well, otherwise this 5% is going on.
let the respondent appear. We'll take up the interim.
Lordship.
Let the respondent appear. We'll take up the interim.
Problem, if I may just produce, Lordship, that's one thing. Page 183. Page 183, Lordship, the order. So if the order is not suspended, if this order is not suspended,
183.
183,
What is that?
183,
Hmm.
the operative portion.
Yes.
Accordingly, both the defendants are jointly and severally directed to pay the total remaining sum of 4 crores to the plaintiff as per MOU dated such and such, along with interest of 5% per annum from the date of passing of the judgment and order. So if this order is not suspended, this 5% has started. This counter is now going ahead.
Yeah, if the other goes, this also will go automatically.
No, sir.
If the other goes, it
Yes.
also will automatically go.
I leave it to your lordship, but then I think it is a fit case where lordship can protect me at least till the respondent appears. On that day, lordship will say, returnable date, till then it is stayed, and on that day, he may always challenge this.
Mr. Sharma. Current counsel for the applicant. Para. This is an appeal under section 96, where order 41, rule 1 of the Code of Civil Procedure 1908. Showing the order dated
Order dated 25/2024.
25/2024.
25/20 in money suit, summary money suit 4 of 2024.
Passed by the
Passed by the Chief Judicial Magistrate come Civil Judge Senior Division.
Civil judge.
Civil Judge, yes, Lordship.
Passigat in summary suit number, where is
4
the number?
of 2024.
Hmm?
Summary suit number 4 of 2024.
2024.
Order and judgment 25/2024.
Yes.
Page 182. Page 182.
One eight two.
Yes, Lordship. Lordship will see the date 25/2024.
2025. 2024. Huh? Date is 20/05/2024. Okay, stop. Huh? The appeal is admitted for hearing. Issue notice returnable by 4 weeks. The petitioner shall take steps upon the respondent by a registered post which vary within a week from today. List this matter after 4 weeks. Stop.
Till then, this order may be suspended. Till then, also.
Having regards to the contention and submission made by the land council for the petitioner. In the meantime, till the returnable date, the operation of the
Order dated 25.
order dated 175.
Order dated 25/2024. Page 182, Lordship. 182.
20/05/2024 passed by the Land Civil Jurisdiction Division
In money suit.
in money, in summary, within bracket money, bracket close suit number 04/2024 shall remain stayed. Till returnable date, huh?
Yes, Lordship. Obliged, Lordship.
Please, your lordship. This is an application of 439 Code of Criminal Procedure. I'm paying for the bail of Hong Kong Khapwang Letting Mate. I was arrested on, your lordship,
Item 10,
Item 10,
regular bail.
regular bail, your lordship.
Just a minute, yeah. Let us see the FIR.
FIR is on page 15, your lordship. Annexary,
Page
page 15, your lordship.
Yes,
Shall I read, your lordship?
yes.
FIR subject. Sir, this is to bring to your immediate action that the above mentioned persons, namely Sri Dathang Suyang, son of Mantha Suyang of village Bodoria, PS Khonsa district Arunachal, and Sri Lishi Roni, son of Lechi.
Okay, when they were arrested? So this is
My
application of-
lordship, I was arrested on 13/11/2020, your lordship. 3.5 years, your lordship.
What is the stage of trial?
Trials, your lordship, there are 38 witnesses. In 3.5 years, only 2 witnesses have been examined, your lordship. Only 2.
Not 2, Your Lordship, more than 2 has been examined and it's in process, Your Lordship.
Your lordship,
So earlier probably you have filed bail application before the trial court.
it was rejected, your lordship.
How many times
Once.
it was rejected? When it was last rejected?
I'll have to look for the file.
Have you annexed? Have you annexed?
It was rejected on 25/8/22. Your lordship, there were 4 other witnesses were examined,
Just a minute.
but
So
a supplementary charge sheet was submitted, so they will have to be re-examined once more,
whether
your
the main
lordship.
witnesses have been, PP, whether main witnesses have been examined,
Your Lordship,
any material witnesses?
yes,
Is that-
yes, Your Lordship. Your Lordship will see the LCR, Your Lordship.
The deposition is also there? Yeah.
Yes,
Deposition so far recorded is also here?
yes, Your Lordship. However, Your Lordship, I've gone through the TCR, Your Lordship. Your Lordship will see charge sheet along with 2 supplementary charge sheet were filed, Your Lordship. The statement of the co-accused under 67 was also recorded, which is not in the record, Your Lordship.
Not in the record.
Not in the, because the record was called on 23rd of April, Your Lordship. Thereafter, since the learned council has taken adjournments on many occasions, Your Lordship, the
So
updated.
in the meantime, some.
Yes,
witnesses
yes,
were
yes,
recorded.
yes.
So any material witnesses have been recorded,
Your Lordship,
examined.
this is a case of,
this period.
this is a case of conspiracy, Your Lordship. His involvement can be ascertained only by the charge sheet, Your Lordship, because all the half of the witnesses whose statement has been taken, Your Lordship, they are just a relative of, and the daughter relative as well as the father-in-law of the.
Any of the accused person has given 164 statement?
Yes, yes.
Okay.
Yeah, there are, Your Lordship. Therefore, I was stating, Your Lordship, under the Evidence Act, in fact, I have a record of, there is another accused who was discharged from the case, Your Lordship.
From same case.
From the same case, Your Lordship, that was challenged.
Time of framing charges.
Yes, that was challenged before this court under revision petition, Your Lordship. By one of the co-accused, Your Lordship. Now this court has
No,
reserved the.
Discharge
By the father
order
of
has
the-
been challenged by the co-accused.
No, the father of the victim, Your Lordship.
Or victims.
Yes, Your Lordship.
Hmm.
Now the complainant, Your Lordship.
What happened to that?
That is that
Statement.
has been reserved, Your Lordship.
Reserved.
Yeah, we are still waiting for the order to.
Okay.
Now, in this petition that they have annexed, Your Lordship, they have briefly annexed all the materials, Your Lordship, under disclosure statement under 27 of Evidence Act has also not been disclosed even in the petition nor is in the record, Your Lordship.
Where do
So
we find that?
we'll have to call for the entire record, Your Lordship. 160.
Disclosure statement is not
Yes.
there and recovery also made.
Yes,
portion
yes.
to the disclosure.
Also on this, Your Lordship, 4 of the accused has given their 164 statement, which is also not in the record.
Okay. That
So
means
we'll have
that-
to, yes, we'll have to,
Can you produce on the next day?
Your Lordship, the registry will have to make a reminder to the Sessions Court, Your Lordship.
Okay. So, but then, along with this, at the time of calling this record, probably there was also called for, no,
Your Lordship?
at the time of calling for this record.
Yes.
Scanned copy.
Yes.
There was also called for.
The record was also called for, yes, Your Lordship. The record does not consist of all the materials
Since it was called.
in the month of April, Your
of
Lordship.
February. Okay. So I think we'll have to call for the updated scanned record. Mr.
P. Kalita.
Hmm?
P. Kalita.
We can the Learned Counsel for the petitioner. Also have Miss Virginie, then an additional PP for the state. Staff. The scanned copy, that's the additional PP submits that the scanned copy available with the record at the moment is of 2000, sorry, of the April month, and thereafter some more witnesses has already been examined. Moreover, some documents, some important.
The statement under 164
Yeah.
and the disclosure under
Some-
27.
Okay, important documents, including
The
164 statement of
statement
the accused,
accused,
164 CRPC statement of the accused, and the disclosure
statement
statement
under 27 of Evidence Act.
under 27 of Evidence Act are also not available, and pray for some time to produce the updated scanned copy of the LCR. The prayer is allowed. List is matter.
Your Lordship, the LCR will be called by the registry, Your Lordship, if the
Okay,
registry is
okay,
directed to.
Okay, not available, and the same may be called for. The prayer is allowed. The registry is directed to issue reminder to call for the updated scanned copy of the LCR and produce on the next day. The list is matter after. This is here only 2 weeks.
2 weeks, after
Who is a
vacation,
holiday?
after vacation, any date, if,
Okay, immediately after
Since
vacation.
I'll be coming from Guwahati, can you maybe fix 29th?
Okay.
29th of.
As prayed for by
July.
the Learned Counsel for the petitioner, list is matter on 29. Okay.
Much.
Deeply obliged.
May I please, my lord?
Yes,
My lord, this is a regular.
the case of the petitioner is that the accused is, on the basis of the FIR lodged by one
My lord, he is the mother, she is the mother, my lord.
Hmm.
Informal, simply informal, XYZ.
received FIR. Name is there. Okay. Mekubenia, huh? Since this is POCSO, I'll dictate it. Can't dictate, no? I'll dictate inside. huh? The accused was arrested, huh? This contention. The accused was arrested when the a case was registered under section 6 of POCSO. Case was registered being Women PS case number 1324 under section 6 of POCSO Act. And the accused was arrested on when he was arrested,
27/3/2024.
27/3/2024.
2024.
And since then, the accused has been lodged inside a police custody, a judicial custody without being released. Stop. Para. Earlier, the accused moved a bail application before the special judge, the Learned Court of Special Judge POCSO Act UPR, and the same was rejected on 28/5/2024. Stop. And this is the subsequent bail application for release of the accused on regular bail. Stop. It is submitted that during the pendency of the bail application before the Learned Trial Court, the police has already submitted a charge sheet and the case has already been taken into cognizance. Stop. This is LCR or?
This LCR lordship.
Okay, the scan copy.
Scan copy lordship.
The scanned copy of the LCR has been produced and I have produced the same. Stop. Considering the nature of allegation against the accused, and the material found on records, and also considering that the the victim is yet to be examined. I'm not inclined to grant bail to the accused at this stage. Their submission will be recorded. This also I'll record because there are certain statements which cannot be dictated here. It's online. Okay. Okay. We'll resume it too.
My lords, with my lord's permission, may I mention an item which was mentioned in the morning, my lords?
Yes.
Well, item 15 was mentioned in the morning by my learned colleague on the other side, Mr. M. Kato.
My lords, I appear for the petition in the matter. I believe, my lords, 4 weeks time has been given to file a counter. My lords, I only request two short things, my lords. We are counsel to appear from outside the Itanagar for the hearings, my lords. My lords, may I request only a date be fixed if it's possible for 29th of July, my lords, in that matter, item 15.
Okay. So in the
And-
last line, is prayed for by the learned counsel for the parties. List is matter on 29.
My lords, and may our names be reflected in the
29
cause list, my lords, because I was unable to join on the virtual meeting because my name was not reflected in the cause list. If my lords, the names A. Sahani and D.K. Boidia may be reflected in the cause list.
You are for?
Petitioner, my lords.
Okay. Let the name of Mr. A. Sahani,
Please, my lords. A. Sahani and D.K.
Okay.
Boidia.
learned counsel for the petitioner be reflected in the cause list. Okay.
Please, my lords, deeply obliged.
Probably is to be stopped. Yeah. Live streaming
Right.
in the POXO case.
Oh.
Yes.
My lord, the IA is for
This is item.
item number 12, my lord.
Yeah.
IA is for, my lord, condoning a delay of 4,920 days in filing the connected civil revision petition. Your lordship may kindly take up the additional affidavit that I have filed.
Additional affidavit
Yes, ma'am. Yes.
in the IA.
Yes.
Okay.
I was granted leave by this honorable court, madam, to file the additional affidavit by order dated 14/12/22. That's an additional affidavit. It was filed in the month 22nd of February 22.
Okay. 23 February.
Yes, ma'am.
Yes.
If your lordship may kindly have page 9.
Yes.
My lord, a money suit was instituted, my lord, 01/2007. Before that, then, my lord, fast track court at Namsai, seeking, my lord, a decree, my lord, against the FCI and the state government, my lord, for carrying out this, my lord, carriage contract under the Hill Transport Subsidy. Now, by this order at page 9, this is dated, my lord.
This is the impugn order.
No, my lord. This should have been impugned in the CRP, my lord.
Okay.
This should have been impugned in the CRP. This is dated, my lord, 27/5/2008. My lord, may kindly note down. 27/5/2008 at page 11.
Yes.
By this order, the money suit was rejected on the ground that the FCI did and the state government has not admitted to the claim. No issues framed, nothing, but that is another subject matter. So this was rejected. Against this, my lord, we filed an application for review as well as, my lord, along with the condonation of application, my lord. If lordship kindly come to page 18.
Yes.
Now the review application as well as this condonation application was also dismissed, rejected by this order at page 18. This
Yes.
is dated 1/12/2009. Now, my lord, against this, we filed 2 civil revision petitions before this honorable court. CRP number 29 and CRP number 30. Now, what happened inadvertently, my lord? The earlier order, 27/5/2008, the first annexure, my lord, 27/5/2008,
that was not put to challenge, man. Only the 1/12/2009 order were put to challenge in two
Only
separate.
the review, order in review.
Yes. Only the order at page 18 was put to challenge.
Oh.
Now 27/5 ought to have been challenged also.
Yes.
Now, my lord, against that we filed two civil division petitions, CRP number 29 and CRP number 30, 2009 before this honorable court. Now, at that point of time, your lordship will in fact recall, the FCI filed several civil division petitions questioning the jurisdiction of the fast track courts in entertaining civil disputes on the ground that the Bengal, Assam, Agra minor civil courts act is not applicable. So these fast track courts, as well as the minors consequently later after the separation of jurisdiction 2010, even the district court does not have any civil jurisdiction. So these matters, my lord, were kept pending from 2009 till, my lord, 2021, when this order at page 19 came to be passed. Page 19. So our civil division petition also was kept pending along with that. There were several civil division petitions. Now, here, this page 19 order, at paragraph 6, by this time, when the Civil Courts Act came into force in the state of Arunachal Pradesh, the matter was remanded back to the respective civil courts. Thereafter, my lord, our civil division petition 29 and 30 was taken up at page 23. Page 23, my lord. My lord will kindly have page number 28, relevant portion. Paragraph 5 onwards. From the perusal of the impugn order dated 1/12/2009, it appears that though the condonation application filed by the petitioner as well as the review petition are indicated to have been rejected, I find the impugn order dated 1/12 to be cryptic one, without any reason assigned for rejection of the condonation application filed by the petitioner. While the condonation application filed under section 5 is rejected, there was also no occasion for the learned court below to pass any order either rejecting or accepting the review petition. To that extent, the impugn order dated 1/12/2009, insofar it rejects the review petition filed with the petitioner, also appears to be an order passed without jurisdiction. In view of the above, having found that the impugn order dated 1/12/2009 to be cryptic one, without dealing with the contentions raised by the petitioner, in the condonation application, I have the view that the impugn order dated 1/12/2009 passed by the learned additional judge such and such, as here above, cannot be sustained, and the same is accordingly set aside and quashed. This is by an order dated 7/2/2022. Now, my lord, paragraph 7 is important. It would now be open for the petitioner to seek appropriate remedy before the appropriate forum against the judgment dated 27/5/2008, passed by the learned additional district and session judge in Manishud number such and such. So inadvertently, that order was not put to challenge, the first order, my lord. So now liberty has been granted to us to challenge that order, my lord. So that is how the delay, my lord. We were all along, my lord, before this honorable court challenging only the order dated 1/12/2009. There was a mistake on the part of the counsels of the, my lord, applicant, my lord, and that is how it happened. So now liberty has been granted to us. What I am submitting, my lord, because of no fault of mine, my lord, I may not be prejudiced, my lord. My lord knows Honorable Supreme Court has time and again held when substantial justice and technical positions are, my lord, pitted against this, that a substantial justice has to be done. My lord will also consider one fact, my lord. 1/12/2009, which is an offshoot of 27/5, has been interfered by this honorable court. Only because of technicality, my lord, we are now caught in this situation, my lord. So, on that ground, my lord, may I rely on two judgments of the Honorable Supreme Court, my lord? Once this liberty was granted, we have immediately filed the civil division petition, my lord.
Okay.
But there has been a delay because the 27/5 order was not put to challenge. That would have been put to challenge. But it is not my fault, my lord. If I may, my lord, rely upon the judgment of the Honorable Supreme Court, 1987, 2 SCC 107.
You have a copy?
I had given a list of books in the morning. I will read slowly.
Okay.
Otherwise, my lord, let them come.
Okay. Read and copy the findings.
Yes, I can, my lord.
You have a copy?
No, I don't have a copy. I have brought the book. I have given a list of the book.
Given the list?
Yeah, I gave in the morning itself.
Okay, ask. Yes.
I'll just slowly read. The legislature has conferred the power to condone delay by enacting Section 5 of the Indian Limitation Act 1963 in order to enable the court to do substantial justice to parties by disposing matters on merits. The expression sufficient cause employed by the legislature is adequately elastic to enable the court to apply the law in a meaningful manner which subserves the ends of justice. That being the life purpose for the existence of the institution of courts, it is common knowledge that this court has been making 1987, 107. Paragraph 5. At the next page. Paragraph 5 at the next page.
Yes.
I read again. The legislature.
No. Paragraph 5.
Paragraph 5, man. 108.
108.
At the top, man.
So please, paragraph 5.
Paragraph 5, man.
No, there's.
Oh, sorry. Paragraph 3, man. 3. I'm sorry. The legislature has conferred the power to condone delay by enacting Section 5 of the Indian Limitation Act of 1963 in order to enable the court to do substantial justice to parties by disposing of matters on merits. The expression sufficient cause employed by the legislature is adequately elastic to enable the courts to apply the law in a meaningful manner which subserves the end of justice. That being the life purpose for the existence of the institution of courts. It is common knowledge that this court has been making a justifiably liberal approach in matters instituted in this court, but the message does not appear to have percolated down to the other courts in the hierarchy, and such a liberal approach is adopted on principle and it is realized that ordinarily a litigant does not stand to benefit by lodging an appeal late. Refusing to condone delay can result in a meritorious matter being thrown out at the very threshold and cause of justice being defeated. As against this, when delay is condoned, the highest that can happen is that the cause would be decided on merits after hearing the parties. Every day's delay must be explained does not mean that a pedantic approach should be made. Why not every hour's delay, every second's delay? The doctrine must be applied in a rational, common sense, pragmatic manner. And substantial justice and technical considerations are pitted against each other. Cause of substantial justice deserves to be preferred, for the other side cannot claim to have vested right in injustice being done because of non-deliberate delay. There is no presumption that delay is occasioned deliberately or on account of culpable negligence or on account of malafide. A litigant does not stand to benefit by resorting to delay. In fact, he runs a seated risk. It must be grasped that the judiciary is respected not on account of its power to legalize injustice on technical grounds, but because it is capable of removing injustice and it is expected to do so. My lord, as seen, my lord, diligently, my lord, for more than 13 years, I was before this honorable court. On the fault of my lord counsel representing the applicants, my lord, not having challenged the principal order, my lord, the delay has occasioned. One more, my lord, if I may just. 1998, 7 SCC 123. Relevant paragraphs, my lord, 9 onwards at page 127.
Yes.
It is axiomatic that condonation of delay is a matter of discretion of the court. Section 5 of the Limitation Act does not say that such discretion can be exercised only if the delay is within a certain limit. Length of delay is no matter. Acceptability of the explanation is the only criterion. Sometimes delay of the shortest ray may be uncondonable due to want of acceptable explanation, where in certain cases, delay of a very large can be condoned or is the explanation thereof is satisfactory. Once the court accepts the explanation as sufficient, it is the result of positive exercise of discretion, and normally the superior court should not disturb such finding, much less in review of jurisdiction, unless the exercise of discretion on wholly untenable grounds or arbitrary or perverse. But it is a different matter when the first court refused to condone the delay. In such cases, the superior court would be free to consider the cause shown for delay afresh and is open to such superior court to come to its own finding, even untrammeled by the conclusion of the lower court. Paragraph 11 now. Rules of limitation are not meant to destroy the rights of parties. They are meant to see that parties do not resort to dilatory tactics, but seek their remedy promptly. The object of providing a legal remedy is to repair the damage caused by reasonable legal injury. The law of limitation fixes a lifespan for such legal remedy for the redress of the legal injury so suffered. Time is precious and wasted. Time would never revisit. During the efflux of time, newer causes would sprout up, necessitating newer persons to seek legal remedy while approaching it. So a lifespan must be fixed for each remedy. Unending period for launching remedy may lead to unending certainty and consequently anarchy. The law of limitation is thus founded on public policy. It is enshrined in the maxima such and such. Rules of limitations are not meant to destroy the rights of parties. They are meant to see that parties do not resort to dilatory tactics, but seek their remedy promptly. The idea is the legal remedy must be kept alive for a legislative fixed period of time. And my lord will have paragraph 13. It must be remembered that in every case of delay, there can be some lapse on the part of the litigant concerned. That alone is not enough to turn down his plea and shut the door against him. If the explanation does not smack of malafide or it is not put forth as part of a dilatory strategy, the court must show utmost consideration to the suitor. But when there is a reasonable ground to think that the delay occasioned by a party deliberately to gain time, then the court should lead against acceptance of the explanation. While condoning the delay, the court should not forget the opposite party altogether. It must be borne in mind that he is a loser and two would be incurred such and such. It would be salutary guideline that when courts condone the delay due to laches, the applicant, the court shall comply the opposite party for this loss. So, my lord, in our case, my lord has seen, we have explained why there has been the delay, my lord. We have been diligently, my lord, fighting this case before this honorable court for 13 years. My lord, honorable Supreme Court has said it is not the duration of the delay, but the causes that is being shown, my lord. Recently, my lord, is our bench also. I will not read this. I will just give your lordship a copy. Here, more than, my lord, 5,000 days was delay was there. Relying upon this two judgment was condoned. I will not bother your lordship. But this is the reason, my lord. Inadvertently, we did not put to challenge the 27-5 order, which the liberty has now been granted. And my lord, I have already submitted earlier also. The subsequent order, which is offshoot of the 27-5 order, has already been interfered by this honorable court. In my humble submission, my lord, I have shown sufficient cause. My lord may kindly consider condoning the delay. And let the matter be heard on merits.
Yes, you file objection.
6, 7, and 8.
Okay.
I will take the law to be first order dismissing the suit, but it is page 9 of the additional application by the deputy king. The judgment starts matter, wherein the money sheet number 1 of 2007 was rejected. The operative part is just page 11 of the additional application.
Additional affidavit. Page?
Page 9 is stop.
Yes.
That is annexure A. This is the money sheet number 1 of 2007. So,
yes.
Part is just page 11.
Yes.
May I give you?
Yes.
I have carefully found and examined the matter available in case record. The process that is submitted by the dated from 24/9/2007 and the submission of the 20 in the ordinary credit history dependent and the FCI account admitted between amount in the registration and the 20 of contested. If I find no merit in this instance, and this should be dismissed before the is rightly, rightly or wrongly, it has been finally decided that money should file. So my humble submission is that when the suit is finally decided, it has come to an end. Remedy lies in the appeal under section 96 of the CPC. I will come again later. Now the petitioner has approached by way of filing a review petition along with the continuation of delay after 1 year. That was also dismissed on merit. Thereafter, the petitioner has filed a civil petition that is complete 14 of 2009. From thereafter, the suit lingered for 10 years. That is okay, right? Because that case was pending before the honorable court panel. Then ultimately it was decided, and then the Honorable High Court, this Honorable High Court has directed the petitioner to seek to go for an appropriate relief matter, indicating thereby that kindly approach with the appropriate petition matter. Now again.
Where it is observed?
Yes, madam, at page 28 of that additional application. It is single petition of the petitioner matter, page 28.
Yes.
And paragraph 7.
Okay.
It will now be open for the petitioner to seek appropriate remedy before the appropriate forum against the judgment dated from 7/5/2008 or that is additional district and session. District John Rohit, district Namsai in Manipur number 1 from 2007 as may be available to the petitioner under the law. That first case which was decided finally by the Namsai court. So here is specific, it is giving a guidance to the petitioner to seek for an appropriate remedy and before the appropriate forum. Now, my lord, again now he has to challenge that order passed by the Namsai court, that is the order judgment dated from 2005/2008. Now by filing of this civil revision petition, my learned friend has challenged that order by way of civil revision petition and this condemnation petition. Now in this condemnation petition, there is a delay of 4920 delay, that is almost 30 years. Now if this delay is condemned, how I will prejudice my lord that I will place before your lordship. Otherwise, the Supreme Court has said that substantial justice has to be given. Now, whether he has gone with the appropriate relief or not, seek for an appropriate relief or not. Now, my lord, it is not the state for whether this honorable court will look into it, whether this civil revision petition will rise or first appeal will rise. But in any case, my humble argument will be that Section 96 will come into play instead of civil revision petition filed by the petitioner.
That will be at the time of hearing of the civil.
Well, let me play. This is my part of my argument, madam. The 96 says the appeal from the original decree, madam. That case has been finally decided. When a petitioner comes for a civil revision, they against any order, interlocutory order, not deciding the case finally. But this civil revision, but this case, money should have been decided finally. It has been dismissed, rejected. So that has come to an end. Now the petitioner has to seek for the appropriate relief, that is the first appeal. Now this, again now coming back to the IA, my lord, the IA number 44 of continued interest for the condemning the delay in approaching by way of civil revision. My argument is that again the petitioner has sought for a inappropriate relief before this honorable court because the appeal lies not in civil revision petition. Now, if it is allowed, my lord, how I will prejudice my case, my lord, after long 13 years. Supreme Court has, my lord, said while deciding the Section 5 petition of the Limitation Act, it has to be seen that the other party is based on the other party should not be prejudiced. Suppose, my lord, if it is allowed, then if again then this suit is again directed to be taken up as fresh. Suppose if we win the case, if we get a decree, then we will also get the decree of the interest on the decree amount, decretal amount. So this 13 years interest will also be counted against me. This is a hypothetical question, madam. I'm just arguing, madam. That in that manner I will be prejudiced. In that case, the Supreme Court has said that period of delay should not be counted for the calculation of the interest. I will face the judgment. And in another judgment, it has been specifically stated that non-entitlement to the interest for the period of delay in filing the appeal matter.
I'm sorry, madam, I don't want to interrupt my friend. These are arguments that will have to be heard when the matter is heard on merit. My lord is deciding, my lord, delay, my lord, today.
How to my lord delay? Because that petition has been
What he is saying is that
I have understood.
Yes.
This will come when your lordship takes up the civil revision petition. And this question of whether the interest should be given for that long years I spent before this honorable, that will be decided only when, if your lordship decide a matter on marriage. Today, my lord, you are deciding only.
No, because it appears that he is objecting, and if you keep on insisting for the interest also, that in your suit.
That is what
clear.
I'm saying.
Hmm.
That will come only when your lordship
Yes.
decides the
There is a.
case
but
on
we-
merits.
Yes.
Today, my lord, is
My
only for
also
delay.
requested that
That I can immediately exit to when the matter is
matter
hard on
and
merit.
if it is concerned that this part should not be taken into account.
So, see his submission. Okay.
Okay.
Yes.
If it is allowed, then the delay portion should not be counted for the calculation of the. I have one case, madam, reported, in Sri Devi Ratla case, madam, reported in 2021 5 SSC 3-1, madam. Paragraph is 25 and paragraph 26.
Paragraph 26.
The court has emphasized that each case has to be balanced on the basis of its facts and the
Yes,
surrounding
mm, mm.
circumstances.
Paragraph 26.
Paragraph 26.
Yes.
The court also emphasized that each case has to be balanced on the basis of its facts and the surrounding circumstances in which the parties act and behave by law. Then paragraph 26 is the observation of one of the case. Then 27 is important matter. The next paragraph 28, I think so. It is evident that the term sufficient for the relative fact dependent and has meaning used largely deriving color from the fact of each case and the behavior of the litigant was its contribution of delay in approaching the court. However, what can broadly say that universally accepted is that principle the applicant must display bona fides should not have been negligent and delay of business should not be such that the contending would seriously prejudice the other party. So, my lord, my humble submission. This line is important. Should not have been negligent, and the delay of business should not have been such that the contending seriously prejudice the other party. My lord, the negligence on the part of the petitioner is that on the first occasion in the year 2009, he has approached by way of filing a review petition, wrong forum, my lord. Then again, that was rejected, then filed a civil revision petition. Civil revision, this honorable court has specifically directed seek for appropriate relief before the appropriate fraud. Now, my humble submission is that civil revision petition ought not to have been filed, it ought to have been first have been filed. So again, the petitioner is negligent, my lord. Now, how it will be prejudice, my lord? I mean, it should not prejudice me. So my humble submission is that if it is allowed, then interest will also be granted, and I will be prejudiced, my lord. That thing has been taken care of in 2023 SSC 255, my lord. That was the line acquisition agreement, my second case.
Para
5.1. Very small paragraph, I will just read it.
Yes.
The aforesaid issue is not less integral. In the case of Viral Singh, while containing the delay in preparing the appeal before this court, while enhancing the amount of compensation at par with other similarly situated landowners, this court has denied the interest on the enhanced amount of compensation for the period of delay in approaching the High Court by way of LPA. Similarly, it is expressed by this court in the case of the February 2. And while containing the delay in preparing the appeal, this court has denied the interest for the period of delay. Merely because at the time of containing the delay, no such condition was imposed that the claimant shall not be entitled to the interest on the enhanced amount of the compensation for a period of delay. The appellant who is otherwise a public body cannot be saddled with the liability to pay the interest for the period of delay, which is not at all attributed to them. Here, the FCI is a public authority, my lord. It runs through the public exchequer, my lord. So the delay portion, it cannot be attributed to me. Under the aforesaid circumstances, the common judgment and order passed by the High Court awarding the interest on the enhanced amount of the compensation for the period of delay in preparing appeals reserved to be caused and set aside. and the impugned order common judgment and order passed by the High Court is required to be modified to the aforesaid action. In this case, my lord, by containing the delay and then again allowing the appeal, my lord, that interest part was calculated. So the Honorable Supreme Court has said that no, that delay portion should not be counted while calculating the interest. So, my lord, if first of all, if the delay is condoned, I will be prejudiced in the sense that I will have to pay the interest if the petitioner wins the case. This is the hypothetical question, my lord, that he has to get a degree on merit matter. My humble submission is that the petitioner still is my negligence in approaching this order. That's all.
It appears this final decision appeal lies, it appears.
No, my lord.
Revision.
No, yes. Revision lies. But today I would not
So,
like to
there-
argue
legally-
that, my lord.
Yes, yes, that is there.
That
But,
is- But I will just indicate, my lord,
so
my
what he
learned
is- what
friend,
he is indicating.
my
is that
learned
he-
friend
Hmm.
has not argued anything on my delay application.
Yes, yes.
He's
No,
arguing on the
What
merit.
he is submitting.
Yes, I have
is that
understood.
delay, if
Hmm.
condoned, the
Yes.
interest, if you are not insisting on the interest, delay may be condoned. What is,
Yes, yes,
that is what you are submitting?
I have understood.
Hmm.
He was negligent.
I have understood, and as
That not be.
as an officer of this court and as a regional person, I will accept that.
Hmm.
The delay,
Hmm.
I was before this honorable court, having not challenged the 27-5 order,
Hmm.
I will accept it. But this order has to be passed in the civil revision petition. But if your lordship deems that it can be passed here also, I leave it to your lordship. But in my humble understanding, that is an order that cannot be passed in the delay application. That will have to be passed in the civil revision petition. Now, my learned friend has argued on merits. I cannot be actually replying to that, but I will just indicate, my lord. These were fast track courts. Powers conferred was the power of the additional deputy commissioner. 1945.
It was not a first track court.
It was fast track court.
There was no subsequent notification also
No.
conferring the civil.
Yes. So
Then probably revision lies.
yes, that is why, my lord, all these years they say
Hmm.
they did not have civil powers. How can now we make this submission?
The exceeding of jurisdiction, it's a revision only.
That will be argued when the civil revision comes. Let my learned friend take that point.
No, just not one
Take
at a
that
time.
point. I am just indicating powers of the ADC was conferred on these fast track courts.
And
Under the
next
45
notification,
regulations.
all those notifications.
Not the district judge.
Hmm.
So civil revision will lie. There's no question 96. But that I will have to argue in the civil revision petition in case your lordship allows the delay.
In the delay petition, have you enacted that order?
No, my lord, he
Because
is
of all
raising it
those-
only now.
Hmm.
That will have to be heard, my lord, only in the civil revision petition. I don't want to make my learned friend wise. My lord will recall, in fact, because all these years, this 13 years, when the FCI before this honorable High Court saying that they did not have civil powers.
Just a minute. Have you given a list of that here?
Yes, madam. '27, my lord.
Just a minute.
Page 9 onwards.
Page
9 of the additional affidavit.
Yeah, page 9.
By this, by the money suit number 107 was dismissed, rejected.
Page 9 of the additional affidavit.
Yes, my lord.
Yes.
It is dated 27/5,
sir.
2008.
Sir.
27/5, 2008.
This is on dated.
27/5, 2008. The money suit was, my lord.
This is 2008 or?
Yes, my lord. 27/5, 2008.
8.
Yes. The money suit was dismissed. Against that, my lord, was filed an application for review along with the condonation application, my lord. That was also dismissed by this order at page 18. This was not even numbered, madam. It is reflected in the Honorable High Court's order also. Against this, my lord, we filed two civil revision petitions, CRP 29, 2009 and CRP 30, 2009,
Please.
page number 23. '29 and 30,
File here.
page number 23. By this, my lord, my lord,
Please. Nine.
by this, the order dated 1/12/2009 was set aside.
By this, order dated 7/2.
1/12/2009.
No, this, what is the 7/2?
This is, yes, my lord, 7/2/2022.
Oh, this is.
By
this
this
is-
Honorable High Court.
This was filed against
Against this order at page 18.
page 18, the review.
Yes, review and the condonation of delay. ma'am.
Okay.
So we filed two civil revision petitions challenging the
These are the CRP 29 and
30.
30 on the next page.
Next page 30, page 24. My lord, with-
CRP 30 is for.
30 was for, my lord, the
Just a
only
minute, by this order, what?
single order was
By,
passed in
just a
page,
minute, by this 7/2/22. So what order was passed?
by this, my lord, the 1/12/2009 order was set aside,
Okay, just a minute, sir.
paragraph 5 and 6,
Order 1/12/9
2009.
set aside.
Yes,
Okay,
granting liberty to seek appropriate remedy before the appropriate forum.
okay, so this is 7 to, just a minute. 7/2/2022.
22, yes.
Okay.
1/12
then
was,
next is,
that's it, man.
Hmm?
That's all.
no.
By this, paragraph
You said
7,
a CRP, two CRP you have filed,
Yes,
29 and 30, where is
yes,
30?
common order, my lord.
Oh, common order.
Yes. There were two CRPs because 1/12/2009 is a common order, but by that, my lord, the condonation application was also dismissed and the review petition was also dismissed.
Okay,
That is why two CRPs. Review as well as condonation application dismissed. Two CRPs.
okay. So,
Then we were also granted liberty to challenge the 27/5/2008 order,
okay.
paragraph 7. And that is how we are before law.
So thereafter you have filed this constitution petition?
Yes,
When 2022?
yes.
So from 2000,
9 to 2022, it was before this honorable court.
how many days total?
4,000, just a moment. 4,920.
Okay, so, the review was dismissed, sorry, your review was dismissed
On 1/12/2009.
2009,
Yes,
and then there has been a gap from 2009 to 22.
yes,
So that period,
yes. We were before this honorable court, madam.
Hmm?
We were before this honorable court. This was pending before this honorable court.
during those period,
Yes. 2009 to 2022.
in which court?
Before this honorable court.
Okay. So
CRP
this
29.
CRP was filed when?
This one, my lord.
Hmm?
This one.
No. The CRP.
2009,
29 and
2009.
Okay. Just a minute, sir.
CRP 29 2009 and CRP 30 2009. Page 12.
Okay. Have you stated anywhere on which date it was filed?
That, my
Okay,
lord, we will have to check the
2009.
records. In any case, my lord, it was, we
Okay,
challenged the
pending.
1/12/2009 order.
$4,000.
920. So 13 years it was pending before this honorable court. That is why the delay. Inadvertently, the 27/5/2008 order was also required to be challenged. That was not done.
27?
5/2008. Instead, only 1/12 was challenged, 2009.
Okay, so 27 were never challenged,
Yes.
challenged earlier.
That is why the liberty now has been
Okay.
granted.
So, you
We
have
have
also,
explained everything in the in additional
Okay.
affidavit. now.
you have also filed objection.
Yes, yes.
Where?
Five to objection, my lord.
You're at 6, 7, 8.
Was
Yes.
from the main case.
Hmm.
Filed on-
Where is your objection? Where have you raised objection? In para?
Yes, my lord.
It is basically that it was my fault. The objection is basically on that.
So you're just 1 minute, 1 sec, huh? So you're just ground, where do we find in para?
In the additional affidavit, ma'am.
Additional paragraph?
It will start from paragraph 6, my lord. I have explained the facts. How it came.
There are 6,
5 onwards, my lord.
5 onwards,
Paragraph 5 onwards.
up to?
Up to, my lord, basically up to 10. 10 is a submission, my lord. Up,
Okay. So detail of the date,
yes,
the explanation has been given here.
yes.
Okay,
I have given the CRP numbers also, how it was pending here.
okay. Yes, your
My-
objection?
my affidavit in opposition, which was filed on 29/7/2022, my lord. Affidavit in opposition. Against the IA. Filed by
Just a minute,
Respondent
sir.
6/7.
Just a minute, huh? Six, 7, and 8. Okay,
Respondent 6/7 and 8.
yes.
My objection is at paragraph 7, 8, 9, 10. Paragraph 7, 8, 9, 10. And again.
6, 7, and 8, para, just a minute, para 6, 7,
7, 8, 9, 10.
okay,
And against the additional affidavit. I
You have filed-
filed my rejoinder
okay.
for the March 2024. My objections are read from paragraph 5 to 12.
2,
5 to 12.
5 to 12. Okay. And then you are for? Have you filed objection? Okay.
How can the state rely on the evidence filed by the
Anything to
FCI?
submit?
Take my.
The 13 years, the interest part, my lord, I am willing to exceed. But that is a case, my lord, order, I understand.
What is your submission regarding, because he says that since there
That
is
I have
delay,
understood.
not because of him, but because of
Yes,
you.
as a reasonable man also, I will have to accept that, my lord.
Hmm.
I will have to concede to that. But whether this can be passed in an interlocutory order or that is the
That,
only,
that can be, because,
if your lordship
Hmm.
deems that it can be passed here, then I have no objection.
okay.
I cannot have. Because
Then
it was my,
with that, we can pass an order. So, giving this reason.
From 2009 to
and-
2022, yes.
Yes. 22, up to the filing of this,
Yes.
22.
Yes, when passing of your lordship judgment also.
From the passing of the Hunsa court matter, first court matter.
That is what I am saying. From
Yeah,
2009 till your lordship this
Yes,
When was that notice?
yes, 2007, 27/5/2008. First order, madam.
Hunsa by 2000.
Yes. That I will have to accept. If your lordship deal, it can be passed in an interlocutory or application also, I am willing. If that condition is there. Obviously, it was my application, ma'am.
yes, yes.
That I
So
understand.
that I'll pass over that then.
Madam.
Heard Mr. Vicky Pange, land counsel for the applicant. I've also heard Mr.
BK Singh for 678.
VK Singh for respondent number 6, 7, and 8. Standing counsel,
Standing now.
standing counsel for the FCI. Respondent number 6, 7, and 8. And Ms. P. Pango, land counsel for respondent number 1 to 5. Oh, sorry. Okay, I'll pass over.
Obliged.
Yes. This person. Just a minute. Item 13. Yes.
Your Lordship,
You did not say.
Lordship, may I please? This is a joint petition under 482 CRDC.
Joint
Praying
petition.
for quashing of the quashing of the
What is the offense involved?
this is a allegation. POCSO.
May I please, your Lordship?
Yes.
Lordship, I'll be representing the sole respondent, Lordship, in this case.
You filed Wakalatnama?
Yes, recently I have filed Wakalatnama, Lordship. I'll need some time to file my response, Lordship.
This is?
CRP, civil revision, Lordship. At least 4 weeks' time, Lordship.
First time, okay.
Lordship.
Yes, I'm appearing for the petitioner
Okay.
and I have challenged, yes, I have challenged this by this revision petition, I'm challenging the order passed by the Learned Trial Court on 1st March 2024.
24.
Yes, so basically the grounds the which the respondents had taken for condemning the delay were found to be false and
Okay, this is condonation of delay.
yes, yes, we are challenging the granting of condonation, allowing the condonation of delay on the grounds of falsity. Because
What
there is
grounds of?
falsity, false statements.
Hmm.
The respondents had taken 3 grounds basically for condemning the delay. First one was the poverty, that is power stricken, they're below poverty line. And the second thing was that they had not received the judgment order of the Gambra village authority.
Delay was condoned
Yes,
by the,
lower
judge.
court. Yes, yes,
and
Your
you are
Lordship.
agreed by the condonation of delay.
Yes, Your Lordship.
Why?
Yes, because the grounds which were taken by the respondent were false statements. They have
False statement.
yes,
Okay.
they have because generally it is very liberal to grant. It is upon the discretion of the honorable court to grant the condemnation, allow the condemnation. But here, when the condemnation that the grounds for the delay are on the false, that amounts to perjury, Your Honor. So allowing the condemnation will amount to
Where is the impugn order? Can we just see one?
yes, is on page number
21. No, the first one.
it's the page number 22, Your
In the
Lordship.
beginning, huh?
21, yes, Your Lordship, which are annexed as Annex 1.
Yes.
So we had even filed our objections in written, and that was not considered while passing this order.
Which one, according to you, is the false statement? Which was false statement has also been recorded by the learned trial judge.
Your lordship may come,
By the impugn order.
yes, your lordship may come to page number 22,
22.
second para, by filing a reply to the miscellaneous case.
Yes, para.
Yes,
Hmm.
para 2, the third line, your
Yes.
lordship.
hmm.
Yes.
Can
Yes,
can
yes.
you read?
Yes, by filing a reply to the miscellaneous case, Mr. Sonso has submitted that the copy of the judgment was furnished to the representative of the Menda clan on 15th May 2023, and therefore the date of receipt of the copy of judgment as 16th May 2023, as projected by the appellant, is incorrect, your lordship. Therefore, there is a delay of 80 days and not 74 days. Also, the appellant is financially stable and is a millionaire after having received compensation amount for the acquisition of Menda community land in the last month of the year 2021. Additionally, the appellant is the owner of a vehicle Bolero Camper 4WDPS registered in his name with registration number AR16A 7224, and the vehicle was purchased in the month of March 2022. So therefore, the three grounds which are financial constraint, delay in receipt of the copy of judgment, and BPL card holder are completely false, Your Honor. The BPL certificate is respect to the year 2004-5 for showing himself below poverty line in the year 2023. The grounds have been deliberately taken with malified intention and to mislead the court, Your Lordship.
But then ultimately, delay was condoned
Yes.
and delay has been satisfactorily explained. Okay, since he is praying for some more time, we can grant.
Yes, Your Lordship, I also have a prayer that since the appeal is pending before the trial court and which is fixed for the hearing, Your Honor. So if, I mean, if that is not stayed, Your Lordship, we will be, that appeal which is pending before, appeal number 05/2023 is pending before the trial court.
So
That hearing
is
had,
there any stay against that?
No, Lordship.
no, there is no
That
stay.
can proceed with.
So if Your Lordship, if it is not stayed and pertaining to this decision, if the civil revision,
Okay, you are against the, you are against the proceeding of the appeal.
yes, because if before the disposal of this one, this present civil revision, if the final hearing is heard, the appeal is disposed of, then the very sole purpose of filing this civil revision would be infructuous, Your Lordship.
Have you made a prayer?
Lordship may
Yes.
kindly see order dated 10/5/2024, previous order, Lordship, passed by this honorable court, Lordship. Coordinate bench order, Lordship. 10/5/2024, Lordship.
So you
This
can-
matter was hard, Lordship, in length. Lordship, interim prayer was also hard, Lordship. Not granted, Lordship. May kindly take up, Lordship, order dated 10/5/2024, Lordship. Last paragraph.
He has also made an observation. For the others.
Yes, before hearing the final observation as in mentioned, Lordship.
The interim prayer made by her, Lordship, by the applicant was rejected, Lordship.
It was rejected. Okay.
Lordship, yes.
Interim
Now,
was-
now they cannot
No,
press
it
for
decided-
interim,
it was-
Lordship.
It was rejected straight away.
Cannot
Yes.
press, Lordship.
So then we'll expedite disposing of, you file.
Yes,
Lordship,
yes,
so,
yes.
so why I'm seeking for 4 weeks, Lordship.
4 weeks is a long time,
2 weeks
short
will
date.
do, Because the interim prayer was also not granted. So in that case, so it have to be expedited.
Lordship.
Yes, Your
2 weeks.
Lordship.
Okay. Ms. B. Bulu, Learned Counsel for the petitioner. So, Mr. Genie, appearing on behalf of the former respondent, only one.
Only the sole respondent.
Appearing on behalf of the sole respondent. Praise for further 2 weeks' time. to file objection. The prayer is allowed. List this matter after 2 weeks. Okay.
Highly obliged.
In the meantime, you file.
Lordship. Obliged.
Yes.
Obliged, your lordship.
Yes. Yes, sir.
Yes. By way of filing this criminal petition under
Respondent
section
number
482.
You are representing?
Huh?
You are representing respondent?
Appearing for
Sorry.
petitioner.
Appellant.
Appellant.
You are for a petitioner.
Petitioner.
Who will represent to respondent number 2? Just a minute. Respondent number 1. 1. Acknowledgement card in respect of respondent to not yet received. Who is this respondent number 2?
Respondent number 2 is the person who lost the FIR.
He's the,
Okay, where he?
he's the informant, my lord.
Informant, where he? Anyone represent?
No, my lord.
So their presence would be necessary. This is basically what case is this? This is
It pertains to a PC Act, my lord, Corruption, Prevention of Corruption Act. This person was serving as a DFO.
the quashing petition. This is
He-
quashing petition.
Yes, my lord.
Then is the respondent number, private respondent number to the informant, his appearance is necessary here.
Let them take
Yes.
first steps then.
Hmm?
They can take first steps.
We have taken the step. And last time, the service was awaited.
Acknowledgement card is still awaited.
Yes,
Their presence would be necessary.
of course, as per procedure that
Yes.
the notice to be served to the complainant. But here the subject matter of the case is between the court and between the state in the regarding only the sanction. Regarding only the sanction. My contention is that I'm a central government employee and state government has got no power to issue the sanction. So they have obtained this, they have issued the sanction. That sanction itself is a defective. It is not a proper, it is an invalid sanction. So on the
Sanction
basis of-
has to be issued by the central government, not by
Central
the state government.
Yes, central government. I'm a central government officer, employee. And
Let us ensure that even if he doesn't appear also, let us report after receipt of the card. If he doesn't appear.
My lord.
But then you see, we need his presence also. So he's a step
Yes,
upon, he
it is
completed.
needed, it is needed, but what he will say about the sanction, this is, I am challenging only the proceeding of the criminal proceeding against the accused. Yes, unless the sanction is valid, it cannot be. And regarding the invalid of the sanction, there is no dispute.
There is no?
No dispute.
No dispute.
No dispute. And as per the order dated on
What is the offense involved? Let us, by the way.
check, they have.
120.
120B.
120B,
120B.
120B read with section 7 of the Prevention of Corruption Act. Now, here in the page 61 and Excel 6. Page 61. This is the order dated on 19/12/2023. Mrs. K. Bagra, learned special public prosecutor is present and has submitted that against the accused HD above, the IO of the case has obtained the prosecution sanction by the state government, whereas at the time of offense, the accused was a central government employee. The learned HPP has further submitted that with regards to the another accused, Rilin Mulom, the IO of the case has not obtained the proper prosecution sanction as the relevant sanction is
So
not.
there are more than one accused
Yes,
in the case.
Yes,
Yes,
Okay.
there are two accused. One is a state government employee. and,
Yes.
My petitioner is a central government employee.
So here in the instant case, the one accused number one, the sanctioning prosecution sanction can be granted only by the central government, and for the accused number two by the state.
Is there?
Okay, but
but-
there, against accused number one, instead of central government, it was prosecution sanction was granted by the state government, and then this accused against accused number two, no prosecution sanction.
Yes, ma'am.
And prosecution sanction necessary in respect of the
Yes, my lord.
two also.
Yes, my lord.
Okay.
It is necessary, my lord.
Kindly be seen annexure page.
Have you filed any?
No, my lord. No, my lord. My lord, the case is very simple, my lord.
Hmm.
Now, in absence of any prosecution sanction, my lord, the court cannot take cognizance, my lord.
Yes, yes.
Under section 197
Why not?
CRPC and 19 of the PC Act, my lord.
Yes.
Now, here is a case where, my lord, the sanction is granted by the state government for a central government employee, my lord, the present petitioner, my lord. But it was wrongly granted, and the court took cognizance of that. thing.
This is already taken.
Yes,
So-
but it was a wrong cognizance, I would say,
Yes,
because
yes.
the court could not have taken. But
Yes.
in the belief that the prosecution sanction was true, but when the case, when the matter came up on 19/12/2023, the special public prosecutor, he apprised the court that since it was a wrong prosecution, the court could not have taken any cognizance. In the meantime, the present petitioner, they filed a discharge application, I application before the court. Now it was said, apprised that since the court cannot take cognizance, my lord, they cannot even go through that I also. So subsequently it was withdrawn. And now the court cannot.
So after taking cognizance, whether the court went on for framing of charge against.
No, no,
accused?
nothing,
No,
nothing.
not yet. Thereafter,
No, until unless
it has not yet proceeded.
No, my lord.
And thereafter, what happens? In the charge sheet, whether the IO has kept open for filing supplementary
Yes.
charge sheet?
Yes, my lord.
That is, whether the supplementary charge sheet filed now?
No.
Supplementary charge sheet has already been
My
submitted.
my lord, you kindly peruse page 62 of the petition, my lord.
Supplementary charge sheet has been submitted after obtaining the sanction. That is on 6 July 2023. Supplementary charge sheet.
And then, at the time of filing supplementary charge sheet, whether the sanction was obtained?
No.
Till now it is not obtained.
Not obtained till
Not
now.
obtained, no. Therefore, my lord, my kindly turn to page
Page
62.
62. Yes.
Last
There are-
time, my lord. The next date is fixed on 15/3/2024 for receipt of prosecution sanction.
Okay.
My lord will tell me if any.
By eye of the case.
Yes, my lord, if any, my lord. So he has passed an order, the special court has passed an order, but he has not taken any cognizance upon that. He has not given any direction as to whether they have to appear or the charge will be framed on that particular date or not. He has just said, since the special court has apprised that no cognizance could have been taken, he just said it is fixed for obtaining of the prosecution sanction, if any. But until unless the prosecution sanction is obtained, the proceeding cannot go ahead because he doesn't have the power, my lord.
In the addition, in the affidavit, which I have filed.
So how are you agreed? Have you challenged this one?
Therefore, my lord, that's what I'm
Come to the-
surprised, my lord.
Annexure
What prejudice have been caused?
Annexure 8, page 4.
Because the proceeding is not.
This I have already filed.
No. So whether have you challenged whether this
Yes.
order dated 19/12/2023 is impugned here in this.
Another order, 26/7/2023. This case is taken up today for the first time before this court on being received of a charge sheet from the OCPS SIT Vigilance Itanagar. After perusing the charge sheet and relevant document therewith, this case is taken into cognizance. This is the order
Cognizance
passed by
taken.
the special judge. That is in the.
But then subsequent order, you see?
Yes, this is the first order, my lord.
That
The
was
subsequent
first
order is the order passing.
Waiting for.
Yeah, 15/9
He has already taken the cognizance.
That part may be questioned, my lord. I don't have any problem with that. The order taking cognizance.
Cognizance has to go.
Yes, my lord. But how can the charge sheet be questioned?
Charge sheet cannot be.
No, that.
And then if
no, no,
if the IO
my
has,
contention is that in respect of the petitioner, because sanction is a integral part of the charge sheet.
Sine qua
Integral
non,
part of the
sine
charge
qua
sheet.
non.
When there is no valid sanction, in that case,
Precondition.
when the integral part of the sanction is not valid, then automatically the charge sheet become invalid against the accused person. Integral part, you cannot make charge sheet separately and you cannot make sanction order separately. Without charge sheet, the sanction order cannot come. Sanction order
No,
come.
we can say they can't proceed. You can't proceed with the
Yes,
trial of
Yes,
the case.
yes, we cannot proceed.
We can't proceed with the trial of the case without obtaining the prosecution sanction against alleged accused persons. That can be. But then charge sheet as of now, charge sheet, how do we set aside or quash the charge sheet? Charge sheet is not a complete trial. So it is true that the
And-
trial cannot proceed.
There are two accused. I'm not quashing and set aside the charge sheet for the other accused. I am irrespective.
No, if you are praying for the
No,
present
whatsoever,
accused, then
madam.
it will go for the other accused also. Because
No.
the other accused,
No, no.
against the other
I-
accused.
No,
also
in
there is no
respect of,
sanction.
in respect of,
Hmm.
in respect of the petitioner. So I am a central government employee. One is a central government employee. When a sanction has been granted by the state government, in that case, then may not be invalid in my part, but it may be valid on the part of the other accused.
Let us see your prayer, whether you have prayed for setting aside and quashing of this order dated 15/3/2024 also or not. Let us see.
I have filed additional affidavit also.
Additional.
Additional.
Okay, no.
And there I have
Just
annexed
show us
the
Is there any
taking of
prayer
the
for setting aside and
taking of the
order?
cognizance.
No, madam.
Then
Prayer. Specifically, I have
just prayed
specifically mentioned.
Quashing of the FIR dated 3/6/2021
Yeah,
and charge sheet dated
And
18/5.
charge sheet.
Yes,
Okay.
madam. Nothing
Yes,
else.
yes, prayer. It is therefore prayed that you, Lordship, may please to admit this petition, call for the record, issue so cause notice to the respondent as to why the FIR dated 3/6/2021, charge sheet dated on 18/5/2023, supplementary charge sheet, and further proceeding of PCA 02/2023
no, this cannot.
in SIC such and such,
This
register
cannot.
such and
No,
such.
this cannot. So where is the prayer for setting aside and quashing of the
My prayer.
allegiance
My prayer
by the
is
Islamic
page,
court below?
starting from page 10. Proceeding of PCA 02/23 in SIT Vigilance Test 07/2022 register under 120B IPC read with section 7 of PCA shall not be set aside and quashed in respect of the applicant, not for the others.
Yes,
For
yes.
one of valid prosecution
No,
sanction.
Learned Senior Counsel, just see. The main order against you, what I feel, is the taking cognizance of the case without obtaining sanction order, and you have not challenged that. It appears.
Yes,
That
for past cognizance, I have filed the affidavit.
In the additional, you have challenged.
Yes, I have challenged.
Let us see.
Affidavit.
So you were allowed to file additional.
Addition, yes, this is affidavit I have filed. It is in the record. Affidavit I have filed. Here I have challenged. Paratri, that as per order dated on 26/7/2023, the special judge PCA, UP Arunachal Pradesh has taken cognizance of the case PCA, case number 02/2023 in SICPS case number 07 without any valid and proper sanction. Therefore, the order dated 26/7/2023 passed by the
Okay.
special
The prayer is
judge.
there. The prayer is there.
Yeah.
Okay. Anyway, so there one more chance can be given to respondent number 2, and thereafter we'll dispose of next 2 weeks.
Yes, my lord.
Earlier also, as per the earlier order.
So
we
now-
were
now you
supposed
have
to
to
consider the case of the interim.
Interim.
Interim, because case is
There is
you have
order,
filed.
interim order.
Yes,
My lord,
interim order, interim order to stay the further criminal proceeding against the petitioner.
my lord,
Yes.
may I please, my lord?
Yes.
When I have submitted that, my lord, since there is no prosecution sanction, the trial cannot go ahead, my lord.
Yes.
There is no question of interim, my lord.
Where is your interim prayer?
In interim prayer, my interim prayer is
In the interim.
in the interim, during the pendency of instant petition, the proceeding of TCA 02 or 283 in SIC section registered under section 1, read with section 7 of TCA in respect of the applicant.
So what
may be
happened after the
suspended
next date fixed
for
of
the
7/5/24? After that, the case has not yet been fixed.
My lord,
After last order 15/3/2024.
for that, my lord,
Fixing on 7/5.
for that I have to take instructions, my lord, because I don't appear in the trial court.
Can be stayed, I think, for time.
But in fact, my lord, even if they,
No, they,
no,
but then the Lanet trial court has fixed the next date and probably it will proceed. We do not know what further
Exactly.
order will be passed.
next
But,
date of the case is 7/5.
but it would be, I mean, infractions, my lord, when, my lord is well aware, my lord, when there is no
Next
position.
stage we'll try to make an endeavor to dispose of the
My lord,
petition itself.
my lord.
But for the time being, for his satisfaction,
Okay.
and since there is also prayer, we'll have to stay. Okay, Mr. Mukh,
My lord.
Learned Senior Counsel, assisted by Mr. Mukbang Pertin.
Mukbang.
Huh?
Mukbang.
MUKBANG. ANG, Mukbang. Okay. So wrongly written, I think. Yeah, huh? Mukbang Pertin, Learned Counsel for the petitioner staff. Huh? Also her Learned Standing Counsel, SIC.
Vigilance.
SIC Vigilance. Huh? Staff, huh? Para. The fourth office note dated 21/6/2024 reflect that the notice upon the respondent number 2 is still awaited. Staff, huh? In view of the above, list is matter after 3 weeks. You want to take fresh steps or just wait for the respondent number 2?
Interim. I'm pressing
interim I'm granting.
Okay.
But then about the respondent number 2, will you take fresh
Yes,
steps?
I'll take.
Okay, then, okay, in view of the Learned Counsel for the petitioner, then leave that order, huh? First, in view of the office note dated 21/6/2024, the Learned Counsel for the petitioner wants to take fresh steps. A phrase for allowing him to take fresh steps upon the respondent number 2 by a registered post with AD card within 4 days from today. Stop, huh? Sorry. Upon the respondent number 2, huh? The step be taken within 4 days from today, huh? Stop. List this matter after 2 weeks. Para. In the meantime, sorry. Hard on interim prayer.
Page 61, my lord.
Upon hearing the parties, it is provided that till the next returnable date, the proceeding,
PCA case.
the further proceeding of the PCA case number 02/2023 in SIC PS case number 07/2021 within bracket. No, this is a PCA. The versus is something different. Shall remain state. Okay.
In respect of the petitioner.
In respect,
because
remain
there-
state in respect of the present petitioner.
Present petitioner.
In respect of the present petitioner, because there are more than one petitioner and more than one accused. Okay. List this matter after 3 weeks.
An endeavor can be made to dispose of the matter in the
Okay.
next 3
List
weeks.
this matter after 3 weeks, on which date this court shall make all endeavor, make an endeavor to dispose of the matter. Okay.
Obligation.
May I please, your lordship?
Yeah.
Lordship, I am put a petitioners here, lordship. It's a joint application, lordship, file under 482 of CRPC. LCR was called for last occasion. I am told that LCR has been received, lordship.
Okay.
So we can fix this matter for admission hearing.
Okay. This is what petition?
Quashing petition, lordship.
Okay.
Issue is with
What is the offense involved in this case?
380, lordship, theft.
380.
Theft, lordship.
Okay.
ATM
So
card was.
what is the stage of the trial?
Prosecution's witness has not been started yet.
Okay.
Charges has been framed and prosecution.
Charge frame under 380 only.
380 only.
Okay. Prosecution, not yet started.
Not
And
yet.
what happened to the item or the article state?
That was, lordship, ATM was taken from the petitioner number.
ATM card.
ATM card. This accused and the victim, they are sisters, lordship. Elder sister and younger sister.
Okay.
Younger sister took the ATM of the elder sister without her permission, and she has withdrawn 30,000 from her ATM.
Okay, and then what happened then?
And then without knowing that fact that ATM was taken by the younger sister, she lodged that FIR.
How the then withdrawn amount?
Amount was used
30,000.
30,000.
30,000.
Was
She knew
used
the-
by her
she knew
younger
the PIN
sister.
number and all.
Yes.
She knew the PIN number.
She knew the PIN number.
Okay. So then what happened after that?
She has engaged some other person, this younger sister,
Huh.
petitioner number 2, she has engaged some other person,
Huh.
petitioner number 3,
Hmm.
to withdraw that amount, lordship, under her instruction. Lord.
Okay, so the petition number three is also.
He is also one of the
Yes,
applicant
yes.
here,
Petition 3 is also one of the accused.
accused, lordship.
Okay, so 3 of them have filed this joint petition.
Joint petition, lordship. Elder sister, lordship.
Okay, what happened thereafter? After lodging of FIR, whether the money has been returned? ATM
Money,
card has been
lordship,
returned?
since she is the elder sister, lordship, of course, lordship, money has been
No,
returned.
no, return somewhere, anywhere reflected?
And
Chart
nowhere,
in the
nowhere,
chart sheet?
nowhere reflected, lordship.
No reflected.
Not reflected. But mutually, it was settled
Now,
way back in
In
2014.
the settlement also, has it been reflected in the settlement?
No, lordship, that part has.
What they said about this recovery of money, because money has been withdrawn, stolen, illegally withdrawn.
Lordship,
Nowhere reflected that money has been returned, card has been returned, nowhere reflected.
card lordship was seized by the police.
Seized, that is why I'm saying, card was seized, must be, and money also, if recovered, must have been seized. Whether it was handed over back to the petitioner number 1.
Mutually, it was handed over, but in nowhere it has been reflected, lordship.
So
that
then-
is admitted
Then how do
fact.
we know that the case is settled?
Lordship, mutual settlement, it's there, lordship.
Where?
Page number 554, lordship. 54, lordship, sorry.
Yes.
Annexure 4, lordship. This mutual settlement agreement has been entered between these 3 people, lordship. The settlement was already done way back in 2014, lordship. But then
The case of which year?
2014, lordship.
14.
Lordship,
I think there's the punishment is
380, lordship.
380. The maximum punishment is trial not yet begun. You said trial not yet begun. What is the limitation?
Charges has been framed, lordship.
Charge frame when?
Lordship, it's there, Lordship. I have annexed that, page 53A, Lordship. Recently, Lordship, February 2024.
Could have challenged earlier on limitation. What is there anything you want from me?
Lordship, actually, I go to the LCR Lordship. Their Lordship, they have issued summon to FIR before
The
the
scan copy or the original?
Lordship. Here, Lordship, scan copy, Lordship.
This is scan copy.
Lordship.
Pending before which court?
CGM Teju, Lordship.
CGM Teju.
CGM Teju. I
Lordship,
think we can dispose of. You have any objection?
Lordship, as per Lordship, there's 380 only 3 years punishment, Lordship. If they have already mutually settled this, Lordship. So in that case, Lordship, as per the Lordship, this guideline, Lordship, there is minor Lordship, these offences may be settled down, Lordship, in the terms of settlement.
Where is the last order? When is the next date is fixed?
was
Still
13.5,
Any interim order passed here in this?
Lordship, the interim was there,
Interim
Lordship.
was there, Lordship.
Interim there.
The Lordship, 10 order dated 10/5/2024, Lordship.
Okay. So I think we can dispose of.
Lordship.
This is in what column? Order. Will pass order, huh?
Lordship.
Okay.
Yes.
Mr. Ginny, Ginny. This is item?
20, Lordship. 20.
Okay. Mr. J. Jinam Junior, Dana counsel for the petitioner. I've also heard Ms. El Hage, Dana additional PP, staff. We'll have to dictate. Later on. Just a minute, if there is a need. Charge has already been already framed.
Lordship.
Against how many accused?
Two accused, Lordship.
Two accused. Okay, they are sister of same blood.
Yes. Petitioner 1 and petitioner number 2. They are
Petitioner is the informant is the elder or younger?
elder.
Elder. The accused is a younger.
Younger.
And who is the third one?
Third one, petitioner number 2 has engaged this third person to withdraw the amount, Lordship.
Who is this person? He is also related?
Not related. He is not related.
Okay.
But then in the statement, he is petitioner number 2 has clearly said that solely on her instruction, he has accepted.
The fact, if it may require also. Okay, just shortly, huh? Later on detail, I'll take later on just on the fact, I'll take in brief. This is an application under section 482 of the Code of Criminal Procedure 1973 for quashing and setting aside of the charge framed against the accused applicant under section 380/34 IPC 1860. Stop. When is this order dated? Washing of the setting aside of the charge and the order, huh? A wide order dated 19/1/2024. And what is this 21/2? What is this? What order was passed on this 21/2?
I think this is for the issue of summon to the PWs.
No, where is this order framing charge against accused?
Page 53A, Lordship. After 53, Lordship. Page
53A.
Lordship.
This is 21.
The charge under section 380 80 IPC read with section 34 is framed in
Yes, yes,
separate
okay.
sheet and it was
Then-
read over.
then write this, huh? Charge, charge sheet file against the accused under section so and so, and the charge frame against the accused dated 21/2/2024 for offense under section 380 IPC, read with section 34 IPC. No, charge frame against the petitioner number 1 and 2.
2 and 3, Lordship.
Sorry, 2 and 3.
2 and 3.
Charge frame against the petitioner number 2 and 3 by an order dated 21/2/2024 for an offense offense under section 380 IPC, read with section 34 IPC. Where is the FIR you have next? Where have you next the FIR? Para,
Page 20, Lordship.
Okay.
Written FIR is at
23, huh? Okay.
23.
Para, the case of the petitioner. The case of the petitioners is that basing on the FIR. No, just a minute. Then I'll give you an opportunity to type it straight away, later on. So, on the case of the petitioner is that on when is the 27/9/2014, Srimati Nanda Kumar of Teju LC line file a written FIR before the OCPS Teju Police Station inter alia alleging therein that she has her ATM card from debit card is missing. And she has received pre-withdrawal message amounting to rupees 30,000 through Teju SBI ATM on 25/9/2014. And press for taking necessary action. Stop. Basing on the above FIR, case being Teju, case being what is the name of the case? Teju PS, no? Teju PS case number 85/2014 has been registered under section 380 34 IPC. Stop. It is submitted that during the registered and investigated into registered under section so and so and investigated into stop. After completion of investigation from the eye of the case, submitted the case into charge sheet against the accused petitioner number 2 and 3 under section 380 34 IPC. Stop. Sarah. It is submitted that during the pendency of the during the pendency of the investigation, it was the mutually settled.
Lordship.
Okay. Okay. It is submitted that the petitioner number one, the informant, and the petitioner number two are a blood sister, and the petitioner number three is one who, on the instruction of the petitioner number two, is stated to have withdrawn the amount from ATM. So it is further submitted that during the pendency of the investigation of the case, the petitioner number one and two, being the blood sisters, has settled the matter amicably between the parties, along with the petitioner number three. So, as per the settlement executed between the parties on 7/3/2024 at Teju, the case has, the case has been mutually settled. The missing SBI ATM card, the ATM's within bracket debit card, has been handed over back to the informant petitioner number one, and in return, the informant petitioner number two, one, has undertaken to withdraw the FIR file before the day due. Stop. Pursuant to the said agreement executed between the parties, the petitioner had submitted the same before the eye of the case and to the court. However, since the offense under 380 IPC is non-compoundable, the case could not be compounded. The case could not be compounded by the trial court, and hence the petitioner filed his criminal petition, praying for setting aside and passing of the where was the order? Passing of the GR case number 85/2014, Teju PSK, arising out of Teju PS case number 85/2014 under section 380/34 IPC. Okay. Any information you need to give? Rest I'll declare, huh? Okay. ये चंबर में डिस्पोज, yes.
Wait, please, your lordship.
Yes, please.
Lord, 482 petition, my lord.
482
petition, I have come against, my lord, issuance of 41A notice against me. Otherwise, procedural parties concerned, my lord. The moment 41A was issued, my lord, I.
482.
482, my lord. The moment 41A notice. My lord. The moment 41A notice was issued, my lord, I approached the honorable.
What is this? 41A.
41A notice.
Okay, notice upon the accused.
Accused, my lord. Vis-a-vis, my lord, exoneration.
What is the offense involved?
Offense 406/34.
Okay, what is the punishment, maximum punishment?
Maximum punishment, my lord, is
3 years.
3 years.
3 years.
Lordship,
What is the status of the case?
Lordship, actually, Lordship, this case is criminal petition, Lordship, it's not maintainable, Lordship. Because, Lordship.
I'm saying, what is the status of the case at the moment?
Status, Lordship, is investigation stage, Lordship.
How do we interfere?
My lord, that is what I'm trying to place before your lordship. My lord, the moment 41A notice was issued, I approached before the honorable court seeking an anticipatory bail. I was granted bail I appeared twice, my lord. Now my
You are
statement-
protected by anticipatory bail.
Anticipatory bail, I was protected.
Okay.
I appeared before I appeared before the IO twice, my lord. Now my statement has also been recorded. But my grievance, my lord, so far as issuance of 41A notice is concerned, my lord. The moment, my lord, 41A notice is issued, my lord, I have been arraigned as one of the accused person in the present case. If the notice would have been under section 160, that IO issuing notice to the witnesses, because
He's a witness or accused?
he has been made an accused person the moment 41A notice is issued to him, my lord.
No,
That is my
according
case.
to you, whether he is accused or witness.
Prospective witness, my lord, in this particular case.
Not even witness.
Not witness, my lord. He, my lord, as an accused person,
What is
he
it?
appeared.
Let us see the FIR.
FIR, my lordship, will find at page 22. 22, my lord.
Are you
It is
named FIR?
Against Panna Dev, my lord.
Your name is there in the FIR?
Not there, my lord. 3 persons' name are there, my lord. One Panna Dev, Anityam Talukdar, and Subro Saha. Some business transaction took place between the informant and, my lord, these 3 persons, my lord. Some business transaction took place, my lord. Between, my lord, the informant and, my lord, the main accused person, Sri Panna Dev. I am Pinakpani Roy. And 2 more persons have been named in the FIR with regard to transaction of certain 30 lakhs of rupees, my lord. Now, my lord,
Yes. The they were to supply.
Panna Dev and these 2 persons, my lord, they were to supply certain goods to the informant. They couldn't supply. They took the case, but could not, my lord, supply. That is why this particular case was filed. This is the sum and substance of the FIR. Now, my lord,
Now, how you have been, your name
this
has been
particular
erased?
person, Panna Dev, my lord, he was implicated in some other cases in Guwahati also.
Panna Dev.
My lord.
The main accused here.
Main accused in this particular case.
Okay.
In one of the case, my lord, he was implicated in a case at Guwahati, my lord. In that particular case also, my lord, I was issued 41A notice.
Okay.
How the reason
because
I'm-
of the revelation of your name by him.
No, my lord, that is not the case. Have a property at a prime location in Fancy Bazaar in Guwahati. He stayed there. He didn't pay my lord entire year's rent. Then, my lord, he at the very inception, when he introduced my lord himself, he introduced himself to be, my lord, supplier of certain goods and materials, because I am a builder, my lord. I gave him, my lord, the work order, and I paid him some money, my lord, and a total amount of rupees 87 lakhs I was supposed to get from him, my lord. But he didn't pay me 87 lakhs. And, my lord, when I was persistently, my lord, I was insisting on to repay of the said amount, he paid an amount of rupees 65 lakhs to me, my lord. And
You were entitled 85.
85. And for that reason, my lord, I filed an FIR against him, my lord, and which was registered, and he was, in fact, my lord, arrested in that particular case. I have annexed that FIR also, my lordship will find at page 43. So now, my lord, the same question arose in Guwahati also as to how he gave me that 65 lakhs of rupees. And notice was issued to me, my lord. In that case, the investigating officer went to the extent of charge sheeting me in the case that I'm an accomplice because he returned me an amount of rupees 65 lakhs.
You failed to show the reason why you were paid 65 lakhs.
I showed, my lord. I showed. It was there on record. And that is why Honorable Guwahati
Here in
High
this
Court
case also
interfered.
have shown.
Honorable Guwahati High Court interfered and was the proceeding against me, my lord. That order also I have annexed, my lord. You will find it page
So here in this
34.
case also, sir, also
Similar
the
footing.
same amount paid by you.
Same amount paid to me by the, my lord, main accused person of the present case.
What was the reason for what you have paid?
My lord, that entire thing, my lord, you will find it page 43.
What it says?
My lord, number one, he was for more than a year. He didn't pay my house rent, my lord. That accumulates more than 15 lakhs of rupees. I paid him, my lord, the work order, my lord, I placed for the 10 lakhs I paid him. So entire transaction I have with
You have the
me,
document to show that?
entire documents I have, my lord. I placed it before the investigating officer of the Pan Bazar
Here
Police
also have
Station,
you annexed
Guwahati.
all those
Here also
documents?
in my statement before the police, I have disclosed entire thing, my lord.
No, whether you have annexed all those documents also?
I
here?
have submitted the FIR also, and those documents I have placed before the police investigating officer, my lord. My statement is there with the investigating officer. That is why on the last occasion, the case diary.
In this petition also, have you annexed all those documents? All those, whether you have annexed? No.
No, my lord.
Okay. What do you want to show? Just-
Lordship, here Lordship in the FIR Lordship, oh sorry, this case report Lordship, the investigation Lordship, in during investigation, this petitioner name was revealed Lordship.
Amount, what is talking
Lordship.
about? And then in the same case, and some also, this
Lordship.
money was involved, and because of this, he was arrested.
Lordship.
And then the said charge sheet
Lordship.
was passed, what was
Charge-
passed?
Proceeding against me, my
Proceeding
lord.
against
So far as
itself was passed.
my name is
Have you
concerned.
produced the same document before the police? Ayo.
I have placed, my lord, the my rent agreement and my lord, the FIR that has been registered, because I filed an
This
FIR
is
against the-
Lordship, the generally for 41H issued Lordship to the notice to the anyone during the investigation Lordship. It cannot be Lordship, they've already Lordship, they have the interim protection Lordship. They are not going to be arrested. Their 41A is the during investigation process, it cannot be denied Lordship.
No, where you produced? When you produced? Because this is the notice under 41.
41A notice, my lord,
Well,
the,
when did you produce?
the language
All those
itself is,
document to whom?
my lord,
All those documents.
my lord,
This is notice under,
the-
this is under section
the,
41.
the notice, my lord, the language itself is very clear, my lord. 41A, notice of appearance before police officer. The police officer shall, in all cases where the arrest of a person is not required under the provisions of subsection 1 of section 41,
Yes, arrest of the person is not required.
not required, my lord.
Yes,
Issue a notice directing the person against whom
yes.
a reasonable complaint has been made. No complaint has made against me, my lord. Or credible information has been received.
No,
Yes,
you,
Lordship.
you say that the transaction, and it
I-
is also reflected that
I-
transaction, you have paid, you have been paid 65
My lordship.
lakhs, and then these, probably this, and then your arrest may not be required.
My lordship, that is
But
not required
your
because
appearance to
Honorable
record
High Court
your
has
statement
protected
under
me.
161 probably is required.
My
Why
lord.
you are not appearing?
No, I appeared. My statement has also been
Then why
recorded.
they
That
have-
is why
they are
on the
issuing
last
case
occasion,
again?
case diary was
Lordship,
called for.
Lordship, see Lordship,
Listen.
this cumulative petition Lordship, they have Lordship, this file Lordship, 40 Lordship, the notice Lordship, 41A, which is Lordship, they have Lordship, annex Lordship. Lordship may kindly Lordship, 41A, they have annex Lordship in the page number Lordship. Lordship, page 23 Lordship. This is dated 33/23 Lordship. This is last year Lordship. And Lordship, here recently only Lordship, he has appeared before the IO Lordship on the 30th of May Lordship. Then Lordship, this 41 is already become infectious Lordship. And this is, yes Lordship, then why have,
Also you have.
No, my
Lordship,
my
they've
case
already
is
appeared
different.
Lordship,
my-
then why
But
this
my-
41 is existing Lordship? This already expired Lordship.
My place, my lord.
Yes.
The moment 41A notice is issued against me, my lord, I've been arraigned as one of the accused person in the present case, my lord. And my fate will be, my lord, either I will
No.
be charge seated or
No, no,
final
this-
report.
This was issued, when this was issued, impugn order, let us see on which date it was issued, just see.
Page
Where is the impugn order? Page
Page 23 Lordship.
23, my lord.
23.
My lord.
And when did you appear before the IO of the case?
Lordship, in the Lordship, last May Lordship, 30th May, he appeared
My
Lordship.
lord, page
In
30.
between that Lordship, they have filed for
Within-
interim protection, they have
You-
already
You
granted
have the
Lordship.
report of his appearance before the IO.
Lordship is there Lordship in the
Case
case diary
diary has
Lordship.
been called for, my lord.
Yes,
At
Lordship.
this
Is it
case,
there,
limited,
Lordship?
my
Yeah,
limited
in the
here would be.
Lordship. Lordship, here is a plaque mark Lordship.
Then it has become infractuous.
Lordship,
You have
that's
to-
it, Lordship.
If it is, I have not been submitted, if I have been, my lord, not sent up for trial or charge sheet is not against me, my lord, then it is infractuous. If it is in the process of, my lord, investigation.
No, this is
No, no,
the
no.
course of investigation Lordship. We
Can I
cannot
counsel?
deny Lordship.
And council, you see, this notice was issued way back in the 33/2023.
My lordship.
And thereafter, in person to this notice, probably you have already appeared.
Twice I have appeared, my lord,
No,
my
appeared.
statement
So
was not
doesn't surprise
recorded,
then. On the, in person to this notice only, you have already appeared.
my lordship. But my lordship may kindly.
It
see
has become
the language of 41A notice, why that was, I was placing, my lord.
Oh, Learned
For-
Counsel, you see,
For that, my lord,
when you have already appeared, what is the relevancy of this notice then? You have already appeared pursuant to, in compliance of this notice, you have already appeared. And the IO have already recorded your presence.
my statement, my lord,
Statement also recorded on 161.
my lordship.
Then how do,
And,
how,
and that is why on the last occasion, my honorable.
it has
court
become infrastructure
was
only.
pleased to call for the, my lord, case diary.
No,
As
no.
for what
Case
is
diary I
the
have
state of
produced.
the
Can you
case.
show me where is his appearance
No, sir.
and whether his 161 statement has been recorded?
No, sir.
But it says something about charge sheet also.
11 lordship, this para 11 lordship.
Para 11?
Lordship.
Okay, on 31, 24, you see?
Up.
Shri Pinak Pani Roy.
My lordship.
Okay, appear before Itanagar PS with pre-arrest bail. Or subsequently he has examined and recorded his. It has become
Up to date
infrastructure.
status, my lordship, may kindly see the up to date status, my lord.
This
That
is-
note,
this is up
the
to
note,
date, 24.
note will come, my lord.
Hmm?
If the matter is pending or if it is charge sheeted, my lord. If it is charge sheeted, my lord, I have no case, my lordship may kindly make an observation and dispose of the matter is in practice, my lord.
Matter has become charge sheeted.
Lordship, it is still investigation stage, lordship. And lordship, during investigation stage, lordship, they have the lordship, they can serve notice anyone, lordship, under 41A. It's not necessary that they are being arrested, lordship. And it during investigation only, lordship, his name is revealed by the one of the accused, lordship.
Whether on his appearance, whether he has been arrested, shown arrested.
No, lordship. They have
How-
appeared
how his arrest
because
was not required.
they have already interim protection is there, lordship.
Okay.
They have already, lordship, granted the interim protection by the honorable court.
So case is
Note-
still under investigation.
Lordship.
Note has to be there because up to date report was called for from the investigating officer. A note has to be
This
there, my
was
lord.
2026, okay. Heard, Mr.
MK Das, my lord.
Learned Counsel for the petitioner. Stop. I've also heard Ms. L. Hage, Danet, additional PP, state of AP.
My lord,
Para.
may I pray one thing, my lord?
Yes.
The copy of the report, my lord, that my learned friend.
No, lordship, I cannot
rely
serve,
on.
no, lordship.
I-
This is confidential.
Because
We
they
cannot
will
share,
allow-
lordship, case study, lordship.
Okay, that's it.
Because, my lord, it would have been 160, my lord. That is notice to the witnesses. Then it would have been a different aspect altogether.
Para. This is an application under section 482 of the Code of Criminal Procedure 1973 for setting aside stroke washing of the notice under notice under 41 notice under section 41A of Criminal Procedure Code served upon the accused petitioner in connection with the Itanagar PS case number 449/2021 under section, just a minute, sir, register under section 44. Okay, under section 406/420/420 of Indian Penal Code, IPC, Indian Penal Code. So, this was filed, when this was filed?
This file on lordship,
My lord, my.
May 24.
20 May, lordship.
Challenging the notice dated, where was the impugn order?
Page 23, my lord.
23. So when did you obtain the interim anticipatory bail? Basing on this notice only you have obtained interim anticipatory bail?
My lordship, 22/5,
No, no.
2023,
Interim anticipatory bail was obtained basing on this.
41A.
Hmm?
41A, my lord.
Okay. You are protected only.
My lord, that is what I am trying to submit, my lord.
Mhm.
I am not on the procedure because the procedural part is complete, my lord. I am protected from the honorable court. I appeared, my statement has been recorded, and that part is a different aspect altogether.
Now,
My grievance is that, my lord, the moment 41A notice has been issued to a person, my lord, he stands as an accused person in that particular case, and his fate comes to an end by way of a final report or charge sheet. If the notice would have been issued under section 160, my lord.
No, just because pursuant to this notice, you have already appeared.
I appeared, my lord.
Yes, you have
And
already
my
appeared.
statement has also now been recorded.
Yes.
That is, my lord, the process I have to comply, my lord. Because if I fail to appear, my lord, the authority has the right to arrest me, my lord. That is with regard to, my lord, compliance. My case is that, my lord, the moment 41A notice is issued, because the language of 41A says that, my lord, if a complaint has been filed against an accused person, a reasonable, my lord.
Now you see, now on your appearance, the police has recorded your statement.
My lord.
And basing on your statement,
My lordship.
probably against the accused, or again, if it is against you, if it was against you.
I have been arraigned as an accused person the moment police personnel served me with a notice under section 41A. If they serve me with a notice under section 160 CRPC, then I become a witness in this, in that.
They have already, lordship.
So that is why.
Well,
on the
they have
last
already
occasion,
granted
Honorable
bail,
Court-
lordship, under 41A, lordship. Then how can he
On the
submitting?
last occasion, that is why honorable court was called for a report, my lord, as to what is the status of the case, my lord, investigation.
Now you see, even if you are accused also,
My lord.
how do we interfere at the time during the investigation period?
My lord.
Even
So
if you are
that is
have
why-
been arranged and accused also.
My lord.
But it will be only possible when the charge sheet is submitted against you.
My lord.
When the case
That
is
is
pending
why
for the trial.
honorable court on the last occasion was pleased to call for a report, my lord, from the
So that
investigating
very-
officer
very-
as to what is the status, my lord. Whether charge sheet has been submitted, not submitted, my lord.
So charge-
Whether
probably
statements
the
have been
case-
recorded.
Lordship cannot interfere,
So
lordship,
if
during
charge sheet is
investigation
submitted,
of
I
the
have no
lordship
case,
case.
my lord. I am conceding, I am accepting, my lord, now. The report must reveal, my lord, that.
Investigation state, lordship cannot be interfered, lordship, by the
I
honorable
am
court.
not
lordship.
asking for any interference.
Then how can
Just
lordship
a minute,
41A
just a
can be
minute,
lordship?
there is- So he probably has also produced all those things. Investigation of the case is completed and case is being charge sheeted against arrested accused Sri Panna, who is Panna Dev is something.
No, no,
No, sir,
this is the main accused person.
On receipt of the original case file from.
This is different case, lordship.
This is different case.
Lordship,
Not the present case.
lordship.
No, the why he has to say here, investigation of the case is completed.
There is only one case is here, my lord.
Hmm?
Only one case, my lord. Itanagar PS case number 449 of the
Regarding-
2021.
You obtain instruction, confirm it. Whether the case, present case has been charge sheeted or not.
My lord.
Because he says investigation of the case is completed
Lordship.
and case is being charge sheet against arrested accused Sri Panna Dev on receipt of original case file from this court. Probably.
So he is the
case
main
file was-
accused person, my lord. That report was called for by the honorable court on the last occasion.
Lordship make.
You obtain instruction. The last one. If the case has already been charged sheeted, this-
That I have,
even
considering-
otherwise also this has become infractuous, but then he is still pressing for the passing of this notice. But then we need to know the case, whether the case has been charge sheeted or is still under investigation.
Lordship, may I, lordship, this is the lordship during investigation, this is the lordship, Paltan Bazaar PS number, lordship. This is a different
No,
case,
that is
lordship.
above. That is above
Lordship.
paragraph.
That's why, lordship, investigation case is complete and yes, this is because this is the lordship, after that, lordship.
Read it. You properly
Okay,
read
then
it.
lordship, I am the
Not
lordship.
the other case. The last one is not talking
Yes,
about.
lordship, then lordship,
I filed it.
That case is different. That case is different.
lordship.
And then last below, the case has been charged, investigation completed. charge sheet.
Lordship, I have to seek Lordship this clarification, Lordship, about this,
Obtain
Lordship, Lordship.
instruction whether the case has been.
Regarding
is
this
still
case,
pending,
Lordship, please, Lordship.
investigation or the
Lordship.
case has already been charge
Lordship,
sheeted?
Lordship.
When?
Lordship, day after tomorrow, Lordship, because this is here only, Lordship.
You are from
I'm from Guwahati, my lord.
Guwahati. When can you come?
On 20.
Because if it is clear that case has already been charge sheeted against that accused, not against you,
My lord.
this is
I-
otherwise
I-
also
I
infractions.
concede.
If-
I accept,
If
my
you
lord.
want this,
I accept.
because
I accept.
otherwise, since you have already appeared,
My lord.
the record reflected
Deeply obliged.
in person to this notice only,
My lord.
then this has become already infraction.
Yes, ma'am.
Otherwise, and if you want to confirm that whether the case has already been charge sheeted,
My lord.
let her obtain instruction then.
My lord.
The May I submit, Lordship, Lordship, during investigation also, if case is not been charged sheeted also, Lordship, 41A can be always be issued, Lordship.
No, no, just-
And moreover,
let-
Lordship,
let
it is
us-
already
let us-
been,
Let
Lordship.
us confirm whether the case has been charge sheeted or not. It's in, because from here, if you are not
But
sure
Lordship,
of-
may I, Lordship?
because order we need to reflect, the case is still under investigation, or the case has already been charged sheeted.
Yeah, Lordship.
This case is this is infractious.
Lordship, Lordship, may I, Lordship, here, Lordship, they are criminal petition, Lordship, not regarding the quashing of the Lordship FIR, Lordship. They are the only,
That is
Lordship,
why I'm
the
saying-
41A, which
That is why
is
to
already
dispose
been
of-
infectious, Lordship.
To dispose
So
of this
this-
one, we need to confirm whether the case, what is the status of the case. Try
Lordship.
and understand.
Okay, Lordship.
One sentence required, and for that you need to obtain instruction.
Lordship.
Okay. Mr. Sorry.
MK Das, ma'am.
Is prayed for by the Rani, sorry, praised for by the Rani Council for the party. This is matter on when?
26.
Give date.
My lordship, this month or my lord, next month after vacation, my lord.
Huh?
This month or next month, my lord, after
This
vacation.
month, do we have
Or
the
next month, my lord, on 26 July, my lord,
26 July?
my lordship.
We'll say 16 July.
16 July, my lord.
Hmm?
16 July.
We'll say 16 July,
What is it?
16, 17, any date on that,
19, 12?
17 July, Lordship.
17 July, okay.
17,
July.
my lord.
In the
I'm
meantime,
so sorry, my lord.
in the meantime,
Can it be on my lord, on 26, my lord?
up to you.
It's Friday, my lord, 26, my lord.
Huh? 26 of
26 July, my lord.
July.
My
It's up to
lordship.
you. Okay. Right. In the meantime, on which date the learned additional PP shall produce the updated CD updated CD will confirm, I think. And you verbally confirm also, and then with
The charge sheet.
specifically,
Lordship.
specifically, if it is charge sheeted,
My lord.
then
My lord.
naturally seal of the instruction. The case has already been charge
My lord.
sheeted, then in that case, we may have to.
My lord.
Hmm.
So,
Yes,
Lordship.
my lord, if
26.
26 for instruction on charge sheet part, my.
Hmm?
Instruction on the part of charge sheet whether it has been submitted or not,
Automatically.
my lord,
Lordship.
my lord.
Obliged,
Deeply
Lordship.
obliged. Highly obliged. May I please?
The learned, just a minute, learned ADPP shall also confirm whether the case has already been charge sheeted or not. Okay. Yes, what is this case about?
May I please, Lordship?
Yes, please.
Lordship, this IA has been filed
This
for
is
a
item 33.
23 and 24.
Okay.
23 is the IA number 100 filed in RFA. In main RFA, first regular first appeal, I am the sole respondent, Lordship. And today I have filed this IA application for a direction to the respondent authority to bring these 4 documents, original documents of these 4 annexures before this honorable affiliate court for proper adjudication of the RFA, Lordship. Lordship, brief fact of the case. The sole respondent has executed some work from the Department of PWD. in the-
Original document, where do we get this original document?
This is with under the control of the department authority. These are the documents issued by the department authority. On previous occasion, Lordship, I have filed an IA
Okay, the
application.
RFA has been filed by the state.
Yes, Lordship, state.
Okay.
And
In the RFA, you are respondent.
yes, I am
Now
responsible.
you are asking for the original document.
Yes,
For
Lordship.
what?
For proper adjudication of this RFA, because these 4 documents was developed, created while pendency of this RFA, Lordship, during pendency of this RFA. In trial court, when, Lordship, the brief fact, Lordship, in nutshell of the case,
I have executed some works with the department in the year 2017. They have admitted my work, but bill was not payment. Accordingly, I have filed a money suit, Lordship, number 6 of 2014. And money suit was decreed in my favor by the Civil Judge Senior Division 0. And being agreed of that decree, they have filed, department authority has filed our present RFA before this appellate court. And during pendency of RFA, the department made a part payment, Lordship, in terms of decree.
To you?
Yes,
Okay.
they made a part payment. Thereafter, some communication letter was issued from the executive engineer for sanctioning of the balance amount for further payment to me. This document was developed during pendency of RFA, Lordship. It was not before the trial court. So I have filed IA number 26 of 2024, Lordship, which was for adducing of additional evidence before the appellate court, because I have to adduce that 4 documents before this appellate court. So prayer was allowed, and I was asked to file a affidavit bringing materials on records of the 4 documents. But since the documents, original documents are not with me, therefore today I have filed this IA application under order 11 rule 14 of the CPC.
Okay. So then in that case, and then because this is the subsequent the document appears to be the subsequent development
yes,
documents,
yes,
and then it is with the department.
Yes, Lord.
So since the IA was the main RFA was filed by the department,
Yes.
and in the RFA you have filed an application for adducing of the
Additional
additional evidence.
Evidence, Lord.
So now probably here also notice need to be issued.
No, Lordship.
So who represent the department?
Yes.
Okay. So what you want to file objection or what you want? What is your submission?
Your Lordship,
So if you agree that we can produce, we'll give direction today itself.
then in that case, Your Lordship, notice may be issued, Your Lordship.
Notice you obtain instruction.
Yes, Your Lordship.
Okay.
Lordship, my Lordship, IA number 26 of 2024 was disposed of. I have enclosed the IA, previous IA also, page 17, Lordship. Just 2 lines, Lordship. And operative person 18, last para. The learned counsel for the respondent, that is me, is directed to file affidavit bringing in records the documents filed as Annexure 1 to 4 in IA
You see,
26.
Since these they have filed with them, there is only you see the Xerox copy or the photocopy. You I think have to file the original.
Yes, original.
So
Since the original documents
and
are,
if they don't dispute, it's your advantage only, because if they accept, yes, this is the same document, no problem.
in that IA Lordship, they have accepted. That's why I was directed to file affidavit. But since the original is with the department.
Original, if they don't dispute, then no problem. If they dispute, then only if you have a copy, if the copy is not disputed by the respondent, then you see that will stand as the admitted document.
Yes, Lordship. That's why
The
Lordship,
genuine document. only.
without issuing notice, Lordship, direction may be
Yes, Your
issued
Lordship.
since
Okay,
their
okay.
documents.
The Mr. Lowland.
Then Your Lordship, in that case, maybe records may be called, Your Lordship.
Okay. Mr. K. Lowland.
Wired Ram, Your Lordship.
What need to be called?
These documents may be called for in court.
Okay,
itself.
Mr. K. Lowland, Lana counsel for the applicant. And also, I've also heard Mr.
Wired Ram, Your Lordship.
Y.
Ridam,
Riram Lanet,
junior government advocate.
junior government advocate. For the opposite, government advocate representing the opposite party number 1, all the respondent.
Yes,
Yes, Your Lordship.
Okay. Representing all the opposite party staff, huh? This is an application under order 11 rule 14 of the Code of Civil Procedure, praying for calling of original documents, stroke records of the annexed document is annexure 1, 2, 3, and 4. You want to obtain instruction or you want directly?
Then your lordship, we may be directed to bring on the records, your lordship, the
Okay.
next records.
Okay. Annex to this applicant. Original documents, records of the annexure annexed to the applicant is annexure 1, 2, 3, and 4. From the opposite party, number 1, 2, 3, and 4, for proper adjudication of the connected RFA number 9, 2018. Stop. So you have to be sure that the original are with you.
Yes, your lordship.
Okay. So, Mr. Riram, Paraha. Okay, just a minute. It is submitted that the above documents, you have obtained this document by RTI. or what?
RTI and
Okay.
copy
The-
was sent to.
It is submitted that the above documents, annexes, annexure 1, 2, 3, 4, and 5. No, 1, 2, 3, and 4.
Yes.
Is it up to 4 only?
4.
Okay.
Yes. Annexure
To the,
1, 2,
to
3.
the applicant, to the present applicant, as obtained by the applicant by way of RTI application. And the original of the said documents would be required for proper adjudication of the present RFA. Stop. Para. Mr. Riram, learned government advocate representing the respondent number 1, 2, 3, and 4. Represent 1, 2, 3, and 4. Submits that since the document has been obtained from the department concerned, the original document is available with the available in the office of the department. Hence, they will be in a position to produce the same.
Yes, your lordship.
Not before the court. So, in view of the above, the respondent shall bring the above documents, annexure 1, 2, 3, 4. The original documents of the above. The original copies of the above documents, annexes, annexure 1, 2, 3, and 4, on record by filing affidavit.
Your lordship, it may not be necessary, your lordship.
To bring on record in the court, you can't present it on the newspaper.
We will just bring out the original, this one, demonstration.
Bring it in the affidavit form only.
Yes, your lordship.
We can't keep it in that.
Yes.
Okay, affidavit form on stuff, It's prayed for by, okay. So this stand dispose of them.
Lordship, let it be kept pending for
Okay.
next step because
Okay.
I'm not sure the copy.
On the next date, So. Is prayed, list is matter, is prayed for by the parties, list is matter. After
4 weeks, your lordship.
4 weeks?
Yes,
After
your
4
lordship.
weeks, okay.
Obliged, your lordship.
Deeply obliged.
I think time of hearing would be difficult.
My lord, quite apart from that, my lord, similar matter is already pending before the Honorable Supreme Court.
Okay,
So therefore, it is may have predicted, my lord, this matter may be listed after 4 weeks,
after 4 weeks.
my lord.
Okay. You are for the,
In fact, the other party, private respondent, my lord, they went to the Honorable Supreme Court challenging the order passed by this Honorable Court.
oh, no, who is the appellant here? Appellant is,
Union
you
of
are
India,
also,
madam.
okay, you are also appellant here.
My lord.
Okay,
The private party, my lord, the order passed by this Honorable Court, went to the Honorable Supreme Court, and the same is pending, still pending, my lord.
okay.
So therefore, my
What is
lord,
this? This is IA. IA in what? In this case,
yes, my lord, along with the IA 34, my lord. In fact, the my lord, other party, private party, they are not appearing. Maybe, my lord, the same similar matter is pending before the Honorable Supreme Court. They don't want to press on IA.
so whether the appeal is pending before the Supreme Court,
My lord,
appeal filed by whom?
my lord, private party,
Okay. So
Srimati
has it,
Deepak Tayang.
whether this record has come before this court in.
My lord, of course, it is another aspect of the appeal, but it is somehow connected, my lord. It is regarding the payment of the compensation, my lord.
Okay. Okay, then you are also representing here?
Two, Your Lordship.
No.
Respondent number two, Your Lordship.
Two, respondent number two.
Yes, sir.
Okay, so after 4 weeks,
My lord.
after 4 weeks, okay, on the joint prayer of the Lani Council for the appellant, Mr. M. Kato, Lani Deputy Solicitor General of India, and Mr. Riram,
Why, Riram?
Lani Government Advocate, this is matter after 4 weeks.
My lord.
Okay.
Debatable.
Obliged.
No one appears on behalf of the parties on call. Case 10 adjourned. This is matter after. This is criminal appeal. 3 weeks. Okay. Any other matter? It will be difficult. It will be listed
Kindly
more
call for
only.
the case diary, my lord. Kindly, my lord. We have already arrested regular bail petition. Kindly call for the case diary, my lord. This month, my lord. 31. Kindly call for the case diary, my lord. My lord, if
Okay,
possible,
hard
my lord.
Mr.
S.H. Sikdar, my lord. S.H. Sikdar. Sobjel Haq
S.A.
Sikdar. Sobjel Haq Sikdar.
S.H.
S.H.
Sikdar,
Sikdar.
Lani Council for the
Petitioner.
petitioner. Staff. Also hard Mr. Mete, Lani additional PP for the state staff, huh? We'll call for CD when?
My
Huh?
lord, kindly on 28, my lord. My lord, because my lord,
Where?
only on
This
absolutely
is police station. This is a bail application under section 439 of the Code of Criminal Procedure 1973 for granting of regular bail to the accused who has been arrested in connection with
my lord, Pasigat PS case number.
Pasigat PS case number 77/2024 under section 399/120B of the Indian Penal Code. Start. Call for the case diary. Since Mr. Ate appeared on behalf, there are other, how many accused?
My lord, 4 accused, my lord.
Why you are filing only one?
My lord, this is my lord, she is applicant, my lord, on behalf of them, my lord.
Your Lordship, this issue has already come before this court, so let it, because
I have seen there is a trouble.
My lord.
Because among these, all are same.
My lord, yes, my lord, they are family members, my lord.
Family members.
Relatives, my lord,
Allegation
relatives of the
against all of them are
applicant.
same.
Yes, my lord.
Who is main accused?
My lord, all the FIR named accused, my lord.
Huh?
All the accused persons are FIR named, my lord.
I think you have to
It's
file
also, no,
separate,
my lord.
because the condition also would be different.
My lord, my lord.
Condition imposed upon while granting bail also would be different. You file separate application for each
My
one.
lord,
They have to file one separate affidavit. Who has signed the affidavit?
my lord, affidavit, my lord, as per their my lord, authority, my lord, authority letter, I have also, my lord, submitted, my lord.
Copy, Your Lordship.
Authority letter also there, my lord.
Who authorized to whom?
My lord, all the accused persons authorized this, my lord, petitioner, my lord.
Who is
Applicant.
Nobita?
My lord, Nomita is the wife of the present accused number 1, and my lord, relatives of the other accused persons, my lord. Authority letter, my lord, kindly turn to page, my lord.
Where is the authorization?
My lord, page 19. It starts from page 19, my lord. All the persons authorized are, my lord.
No, this will be trouble.
My lord.
You file separate application for each one of them.
Your lordship, if they are
There
in.
we found it different.
And your lordship,
Because
the
in a
issue,
case, one was main accused, one just named, just.
All are, my lord, similar footage, all are.
And then,
No.
sure the amount was 2 lakhs for one, and whereas the other.
No,
for
no,
other,
my
it
lord.
would have
Actually,
been
my lord,
10
this all are
10,000.
similar footage.
And your
Similar
lordship,
footage,
one
my
more
lord.
issue is there, your lordship.
Similarly situated.
It
my lord.
has
That
to
is-
be countersigned by the jail superintendent, your lordship.
my
If
lord,
they are in
Ukalatnama-
custody.
my lord, Ukalatnama countersign is there, my lord.
Where is the jail superintendent?
My lord, Ukalatnama kindly see, my lord.
In authorization
the
letter, when
Ukalatnama,
it
my
has
lord.
been granted, your lordship.
Authorization is there, my lord.
There must be an, your lordship, the countersigned by the jail authority in the authority letter
Ukalatama,
itself.
kindly see the Ukalatama, my lord.
No.
My lord, in my lord, we are, my lord, from Guwahati, my lord, that is why in Guwahati High Court, my lord, the regular branch, my lord, it is permissible. That is why, my lord, we have filed.
Even authority
And
letter,
authority-
your lordship, the authority letter should be countersigned by the jail authority, your lordship. Whether it has been procured by the time when they were in the custody or not, how that can be ascertained, your lordship.
Ukalatama countersign. Because at the same time, it was.
This issue, your lordship, we already deal with it, your lordship. The same issue. Again, the same issue, your lordship. Affidavit and no doubt, your lordship, or they all are in the custody, but your lordship, so far as the authority is concerned, it has to be, in my humble understanding, your lordship,
No.
countersigned by the
No.
jail
My
authority.
lord,
your
my
lordship.
lord.
The authority letter.
My lord.
Written by each one of them has to be the sign of the jail authority.
Yes,
that is why, my lord.
In the jail authority,
My lord,
in the Wakalatnama,
my lord.
you did not say that you are representing
Exactly, your
these, and signed by jail authority. No, jail authority need to identify that you are, this authorization
My lord,
letter
actually-
is by this accused.
My lord, actually, what happened, my
No.
lord, during police custody, they
No,
were, my lord, police custody for a long period of time, my lord.
No.
On 11, they were produced, my lord. And there are, prior to that,
No.
my lord, they were in police custody,
From this,
custody, my
you
lord.
can't say
My
that because it's only one person has signed here. And
My-
then later on you have included two somewhere.
No, no, my lord.
No.
No, my lord.
You
Because,
see, only one person has signed here.
yes, my
And
lord,
then
that is.
against one person, only the jail authority has put his signature.
No. Then my lord, we'll file separate one, my lord.
No, file separate one.
Yes, let them
Then
withdraw and file
we'll
a
take
fresh.
up. So tomorrow, any day,
My lord.
any day, tomorrow, any day. You file.
At least authority
So, my lord,
has to be countersigned.
No,
separate-
authority
we
is
should
just
file
guessing.
separately, my lord.
Yes, separately.
Okay, my lord.
It's always better.
My lord.
Because we have found difficult. for
Involvement
execution
is also
also.
different, your
And
lordship.
then one person is a main accused,
Right.
against him surety amount,
Hmm.
Right.
2 lakhs, sorry, bail amount 2 lakhs, surety, one local bail.
Right.
Local,
Local
surety,
surety,
etc.,
yes.
if we pass. And then another, against another person on perusal of the records, it appears that he is not a main accused.
Okay, my lord.
And to him, we can
We'll
release
file separately, my
on
lord.
execution of a bail amount of rupees 5,000 also.
Right.
There is injustice, you see.
Right.
Hmm?
My lord, we will file
Better
separately,
file
my lord.
separate.
My lord.
Hmm.
So it will, I want to withdraw, my lord, please.
Okay. As per, the land council for the petitioner wants to withdraw this bail application with liberty to file a press advice. Stop. This bail applications is dismissed on being withdrawn with liberty as prayed for. Okay.
My lord. Obliged, my lord.
Please, your lordship. Lordship, a case has been lost, registered against me, under section.
What is the offense?
Offense is 354A, sexual harassment, lordship. And I have been served with a notice under section 4, cooperate with the police, lordship. Therefore, I am seeking some protection so that I can cooperate with the police.
Where is the FIR?
Yes, lordship.
Sanjeev, your lordship may directly first come to the affidavit part. Let's verify that first, your lordship, because the FIR, the name, my FIR, the name is Kadar Gori apartment, something, name is not there. Name of the accused person. Affidavit base 9.
Page 9.
Yes.
Affidavit. Who is the petitioner here? Who is the accused?
Accused is Sanjit Kaur. Sanjit Kaur.
Sanjit Kaur, lordship.
Sanjit Kaur is the accused.
Accused, lordship.
And who signed this affidavit? It can't be. It has to be accused person who.
Yes, person, the Sanjit Kaur signed the affidavit, lordship.
It's in my affidavit, it's written Kedar Gori
Kedar Gori
apartment.
No. This is the name of the apartment where he is reside, but
Where is the
somehow,
name?
yeah, name there is typographical error.
See,
Lordship.
Your
Oh, no, you can, no, this
You
one.
have to correct it, Your Lordship.
You have, it has to be.
I may be
accused.
allowed to correct the, so on the next, tomorrow may be listed, Lordship. So that I.
There is no name, you have,
Yes, no
no
name.
name at
no-
all.
How you will
No, no,
swear it
How you-
without
you
withdrawing
have
the same?
to- You have to
no,
declare.
I will correct the affidavit portion, Lordship.
You have to put the signature and correct the name, again take the signature. Because your name is not there. You are simply saying I.
Name is not there, Lordship, but signature is his signature, deponent.
No. Then, how you will correct, you will have to sign again.
Yes, Your Lordship.
Yes, I have to sign again, Lordship.
Withdraw. Land Council, for the petitioner want to withdraw this bail application with liberty to file afresh after making necessary correction. Staff, the prayer is allowed. This bail application stand dismissed with on being withdrawn with liberty is